Lawyers of Reddit, what was your oh shit moment in court? I was prosecuting a contempt action in family court, something that basically never works, and everyone in the room could tell I was winning. The other side was unprepared, out of arrogance, and I was basically ripping this guy to shreds on cross-examination, which his lawyer didn't even think would happen, because he expected the case to be dismissed. At the end of the trial, the judge ruled for me, and stated that she found the defendant's testimony to be untrustworthy. I was shocked at winning a contempt trial to begin with, but then this exchange happened. Defendant's attorney, Your Honor, now that you have found my client's testimony to be untrustworthy, I'm requesting a continuance in order to prepare further witnesses. This concept is shocking in and of itself, because to even think you can bring more witnesses after you rest your case is laughable. Judge, you had your shot and you missed. Counsel, defendants. Attorney, Your Honor, there was no way I could have anticipated that you'd find my client's testimony untrustworthy, and as such, I didn't have the opportunity to prepare other witnesses in support of his position. Point judge, that may be an argument for your career, counsel, but it holds no water with me. See you this afternoon for sentencing. 4. Those who didn't pick up on it, the judge basically told the lawyer on the record in front of his client that she expects him to get sued for malpractice because he faked up so royally. Point. That shit was mind-blowing on multiple levels. Not a lawyer, but I had a big oh shit moment. Point. I was in court for driving while suspended in a county and in front of a judge that were both notorious for putting people who did that in jail. My license wasn't supposed to be suspended. A pencil pusher forgot to press a button or something and it never got unsuspended after the time was up. I had proof of this, but I was still really nervous. The guy who went up to the judge before me walked to the table where we were supposed to stand, sat down, and put his feet up on the table. The judge asked him what he was doing, and he gave a flippant answer and basically told the judge to get faked. This seriously pissed the judge off. The judge went off on this guy and the guy gave everything right back to him, pissing him off more and more. The judge ended up jailing him for contempt and had the bailiff cuff the guy and put him in a chair off to the side to await the marsholes who would transport him to the jail. Point. My name gets called. The judge is looking at me like I'm fresh meat and he is a great white shark. I'm already thinking to myself, okay, if this judge puts you in jail, run over and beat the shit out of the guy that pissed the judge off so badly. He's why you're going to jail. The judge looks down at his paperwork and back at me and says, you're Mr. My last name? I said, yes sir. He said, yeah, we were talking about you earlier. I'm going to void your arrest and dismiss this case. Your license was supposed to be valid and you shouldn't be here. I let out a huge sigh. The judge asked me if I was okay, and I said I had been a bit worried, especially given the guy that was right before me in line. The judge said, don't worry about him, he won't be seeing anything that I said behind bars for about 90 days, and laughed. The best oh shit moments are when your opposing counsel or opposing client says or does something that wins the case for you. True, in civil cases you usually know what will happen ahead of time, but in my state discovery in smaller civil cases is more limited, and clients don't always want to spend $30,000 when we can get the same result for $10,000 in an adverse possession case. The witness only needed to say I use that area as my backyard, and I fully expected him to say this. It would harm my case, but I knew I could get around it. When asked about his use of the, he said, no, I never really went back there, didn't use it at all. Lost the case for the other side, and I could barely keep a straight face. It was completely opposite of what the witness had told opposing counsel off the record. Apparently the under penalty of perjury made him change his story. Point. I had another case about losing multi-unit dwelling insurance because a guy's place was a fire hazard. I asked him if his personal insurer knew about the fire hazard. Yeah, and the jerks cancelled my policy. I also love it when I have a difficult party on the other side and the judge rips them a new one. I had a convoluted case with a lot of parties about nothing at all. The plaintiff was Enos. The 6 or 7 attorneys were working out calendars with the judge when the plaintiff starts yelling at her attorney from across the courtroom because she didn't like that he had conceded some little non-issue. Judge told her to sit down and shut up. I was sad that the case settled, because she would been amazing on the stand. New judge with a chip on his shoulder. Plaintiff called me to get an adjournment on a summary judgment motion I had made. They wanted more time to submit opposition. I don't have a problem with this, but the court refuses to accept the adjournment request over the phone and says we have to appear in court the next day. So I go, and plaintiff doesn't show up. When our case gets called, I request the adjournment and the judge explodes on me, demands to know why, insists he doesn't grant adjournments, just yells for no reason in front of a courtroom full of attorneys. I tell him it's plaintiff's request, and they are not there. They want more time, but he doesn't want to hear it, and just says request denied. Call plaintiff and tell them to get here by second call. So my oh shit moment is that I just won my case, because the judge decided to be a butthole. I call plaintiff and let them know what happened and they panic. They are about to lose their case. The judge has to grant my motion. It's unopposed. There is no way they can get an attorney to court in time. So the case is called again, and again I'm the only attorney on the case. I go up to the defendant's table with the biggest shit-eating grin on my face and say, Your Honor, I'm here on behalf of defendants with an unopposed summary judgment motion. Everyone that saw me get yelled at suddenly realizes what I was doing, getting yelled at for trying to be helpful, and what judge's outburst meant. I win. Suck it. The judge has no choice but to soften and rehear my request for an adjournment and grant it. Follow up. Plaintiff's client died and the motion was never opposed or heard. When they tried to reactivate the case with an administrator, I reminded them that my motion was the first thing to get heard once the case was restarted. They actually read it, knew they had no chance of beating it, and discontinued against my client without ever having to argue the motion. I was a baby lawyer in my first year representing the 19-year-old child of some rich people in San Mateo County, CA. My client had gone on a bit of a shoplifting spree and we were cleaning all her cases up with a global plea, meaning we handled them all at once. Being new, I filled out the plea form wrong, swapping the counts she was charged with for the counts she was pleading to. It's an easy mistake to make. Every court has their own unique form, and I was unfamiliar with San Mateo's. The judge calls my line, starts reading off the plea form, notices the mistake, and then starts screaming at the top of his lungs. Counsel, what is this? What is this? Is this your first day on the job? This is a court of law, and we do not accept mistakes. Fill this plea form correctly, or I will have you taken into custody for contempt. I did not expect a reaction like that. My client, who had clearly just taken a huge bong rip at 8 AM and who was wearing an all pink velvet tracksuit, was looking at me like I was the biggest idiot in the world. I corrected the plea form. The judge made me wait until the very end of the calendar to take my plea. Afterward, he called me up to the bench. In private he told me, sorry to ream you like that. Everyone messes the plea form up, so I always pick the youngest lawyer to yell at. The older guys will grumble and complain, but if you noticed, they all fixed their own forms and we didn't have any more problems. Keeps the calendar running smooth. Where did you go to law school? After that he invited me into his office for coffee and gave me some really good life/work advice. Turns out he likes talking to new lawyers. TL. Doctor, judge loses his sheet in court over a simple mistake. Turns out it was all a show for the other lawyers and I have one of the worst/best court experiences of my early career. Represented a woman charged with multiple very serious felonies. She insisted that in the months before the offense, she'd been seriously dating one of the detectives who ultimately wound up investigating and testifying in her case. For a variety of reasons, I trusted this client and believed her, even though the detective never disclosed the relationship in his report. So, during his testimony, I asked Detective Smith, you had a romantic relationship with Ms. Defendant, correct? He goes, what? No, and is visibly offended. The judge looks at me like I've lost my mind. The Commonwealth attorney audibly says, what? I'm freaking out because a large part of my cross and argument was focused on the bias formed by the prior relationship, and now I've got nothing, and I've lost all credibility. I try again. Detective Smith, have you had a sexual relationship with Ms. Defendant? As the Commonwealth rises to object, and the judge starts to scold me, the detective goes, oh, yay. we've had sex. It just wasn't very romantic. Edit/update. State is Virginia. The jury acquitted my client of the relatively minor charge that the detective in my story was involved with, but convicted of the other, much more serious charges that detective had nothing to do with. There was a confession and video on the serious charges, so it was kind of a no-brainer. Sorry, I'm being kind of intentionally vague. There are no confidentiality concerns, since this all happened in open court, but it's distasteful to give out too much information about a client. Point: the detective was not disqualified. His testimony was not thrown out. Impeachment, no matter how good, doesn't result in you getting to throw out a witness's testimony entirely. By the way, it wasn't really the sex that was the issue. It was that he didn't disclose it to anyone, and his repeated insistence under questioning that he didn't disclose it because it was irrelevant. Like Watergate, it's not the crime, it's the cover-up that gets you. But I don't get to demand the judge throw out the testimony or that charge just because the cop failed to disclose a prior relationship with the defendant. I just get to point it out, argue it in closing, and then hope the jury also sees the relevance. Corporate lawyer but took on a pro bono immigration matter, helping a victim of domestic abuse get her immigration status sorted out. She had been in the country for 20 years, originally legally, but not anymore. Point: it took us multiple months to get a hearing scheduled. We've spent hours in US Customs and Immigration Services offices by this point. Her situation is somewhat precarious, and we need to resolve this. She told me a few weeks before the hearing that she needed to reschedule because she was going to be out of the country. She said her daughter was going through a high-risk pregnancy and would be giving birth during that time, and my client was the only caregiver/available family for her daughter. That's fine. We put together a letter, get a note from the daughter's doctor about the medical necessity, etc. USCIS gives us a hard time about it, but ultimately hearing is rescheduled. Point: my client and her other daughter come to the rescheduled hearing. Client gets asked about recent trips out of the country. Well, I went on vacation to my home country last month. Instant cringe. She's in the US illegally, and it's unclear whether or not she should have been traveling on the passport she was. I jumped in and tried to clean it up for her, and thankfully the USCIS official was more interested in moving us through the system than getting hung up on past issues. However, she within an inch of this all collapsing around her / getting kicked out of the country. Point: added to it, I believe my client's trip was justified and necessary. I think she just misspoke. I spoke to both the pregnant daughter and the doctor who was caring for her while all of this was playing out. Still a scary moment. My client is the one that probably thought, oh shit. Before trial, I was trying to convince my client to give his ex-wife $200 in child support monthly while he was looking for a job. He had a job, but he was paid under the table for the exact reason of him not wanting to pay for child support. I tried to explain to him that if we go into the courtroom without an agreement between him and his ex, the amount the judge will impose him would probably be a lot higher. He kept saying he couldn't pay that much, that he was jobless and poor. After fighting with him about how the judge won't care about this and how he should be a decent parent and take care of his kids, he said to me I should have gotten a male lawyer. Woman just don't get it. Since I was doing this for free, I just told him to fuck himself and that he was trash and left him to look for another free lawyer 20 minutes before his hearing. Edit. Oh my god, thank you for the platinum. This is the first time I get platinum or anything, lol, and I'm so happy it was, because I told an asshole he was trash. Edit 2. More to the story, this was the second time his ex-wife sued him for child support. The first time she did, she got told by the judge that she needed to get a job, that child support was a 50 over 50 thing, so that she couldn't stay as a stay-at-home mom, and she actually did started working. Point: the guy was such a big oven as that he chose to lose his well-paid job in a bank than to pay child support. In my country, many banks have a rule that if you get sued for child support you can get fired, but this only happens until the bank gets the paper from court asking the bank to detain a percentage of their salary for child support. If you reach an agreement on the first hearing, this won't happen. So yeah, he chose to lose his job only so he wouldn't pay child support for his 2 kids. I did jury service back in the 90s in the UK, a 4-day trial where an estate manager, dude in charge of the farms on a big landowner's estate, was on trial for growing and distributing cannabis. The police had raided the greenhouses and surrounding land and found tons of weed in all stages of production. Dude claims that he is addicted to cannabis, and because his tolerance is so high, after smoking so much for so long, that he can only get a buzz from the very tips of the plant, where the THC content is most intense. Asks the court to believe that he just discards the rest of the plant, doesn't sell it, doesn't even give it away, just destroys the rest of the crop. So it's the last day of evidence, where both sides sum up their case and remind the jury of the salient points of what's been said. Dude himself has been quiet and respectful throughout, smart suit, softly spoken, stuck to his answers. I'd say the jury is not buying his claim, and as the judge reminds us, it's not about whether we think it should be legalized, it's not about whether we think he has even sold the remaining bits of his plants. All we need to find him guilty is to think that beyond reasonable doubt, he had at some point shared a single joint with a friend, and that was enough to convict him for supply on the counts against him. So the jury isn't buying his story, but we are also looking at him thinking he's quite old, isn't doing anyone any real harm etc. is unlikely to be running a massive dealing empire. Then on that last day, the public gallery, which has been empty all week, is suddenly full of the most blatantly stonery stoners you've seen in your life. One of them is even wearing an Adidas Adahash t-shirt. The jury files in, we sit down, we look at the public gallery and I think it's safe to say we stare at them. Defense barrister turns to see what we are looking at and visibly slumps, then glowers at the solicitor and hisses really. Such an own goal. TLDR marijuana farmer fucks up by letting his customers come to court. I'm not a lawyer, but I work for a lawyer. Many years ago my home county went through an abrupt and involuntary change of judge when one of the sitting judges was suspended and disbarred for bad conduct. This process took months, where our criminal docket was handled by a carousel of visiting judges from other counties who couldn't care less about our community and quickly came to resent having to fill in on the bench while our judge was prosecuted, and the governor went through the slow process of appointing a replacement. It was standard for cases to just get set off or delayed. Our docket swelled and the jail emptied because very few people were being sentenced to jail. The visiting judges would grant low bonds, or all bonds in all but the most serious felonies. Petty criminals who didn't negotiate a plea with the prosecutor just reported back to court month after month with no disposition. One afternoon an attorney presented for plea a man accused of domestic violence for boxing his child's ears. This was to be a routine plea for probation and anger management. When the facts of the case were read before the latest judge, he looked up from the docket and pursed his lips. When the prosecutor announced the parties had reached a plea agreement and the conditions, and asked the court to accept the plea agreement, the judge stated simply, "No," and directed the defendant to have a seat. The defendant looked anxiously to his attorney as the judge outright rejected the plea agreement and sentenced the defendant to 30 days in jail. Well, the defendant freaked out, as did his wife who loudly protested she needed the defendant at home working. The judge pointed at her from the bench and told her to shut it, or she would spend 30 days down as well. Well, the defendant's wife collapses into a weeping mess of bleach blonde hair and Khmat couture. The bailiff, who frankly looked surprised at being asked to do anything aside from remind people to remove their hat, escorted the defendant downstairs to the jail. The attorneys, prosecution and defense, looked very much like two children who were in trouble, but they weren't quite sure why. Once the shouts of the defendant faded into the belly of the courthouse and the sobs of the white trash in the back of the room slowed, the judge addressed the court. "Look," he said, "I know you all have a deal. And you know I don't have to accept it. I can leave him down there for 30 days. 30 days being a more than reasonable sentence for misdemeanor assault on a toddler." The judge continued, "I just want to teach him a lesson, and I will. You see, when I was a kid, my dad boxed my ears. He did it often, and one day he did it so hard, I'm now deaf in this ear. I know you all think it's no big deal," he addressed the defense attorney, "and you're pretty used to getting away with sweet deals for a while now, because you haven't had a judge." He leaned back in his chair and surveyed the courtroom. "But this one hit a nerve with me. and you can file whatever complaint you want later, but I'm just going to let that guy sit down there for a couple of hours and think about what he's done. Then I'll bring him back up." Well, we were stunned for sure. After months of just watching criminals come and go in a never-ending circle of arrest, plea, probation, it was honestly a shock to see someone sentenced to jail at all, much less in such an abrupt fashion. Toward the end of the court day, they brought the earboxer back upstairs. He got a lecture and tearfully promised never to box his kid's ear again. But seeing him go to jail like that, even just for a couple of hours, was a pretty big O-seat moment. Edit. Boxing someone's ears is when you slap them on the side of the head, so the cupped palm covers the ears. It is very painful and can rupture an eardrum. This was told to me by a legendary trial lawyer in my area. I probably have some of the details wrong, but here is gist. It was a personal injury case against the manufacturer of an industrial fan. It was supposed to be child safe, but a kid got their fingers chopped off. The manufacturer was claiming that the plaintiff was only injured because the fan had been modified from its original condition. The defense lawyers had an exemplar fan that was straight from the manufacturer. They brought in an expert and, on direct, had him explain how it would be impossible for this kid or anyone else to hurt themselves. The idea was that the guard mechanism would have prevented people's fingers from getting too close to the blades. He was a well-qualified witness and gave very compelling testimony on direct exam. Unbeknownst to the defense lawyers or judge, the plaintiff lawyer had brought a very long extension cord and plugged in the perfectly safe fan. On cross-exam he went over the expert's theories and had him say unequivocally that it is impossible for someone to injure their fingers on this fan if it is unmodified. The plaintiff lawyer then walked all the way across the courtroom, turned on the fan as high as it would go and began walking it towards the expert. It was loud, so he had to kind of shout over it. He definitely had the jury's full attention. He gets right up to the witness and starts in on him, still half yelling due to the noise. "Show us. Stick your fingers in." "No. Come on. Stick your fingers in." "I don't want to do that." The other side is jumping up to object, but the plaintiff lawyer is 2 inches from the expert yelling for him to stick his fingers in. The expert is looking terrified and shrinking away from the fan. The jury came back in favor of the plaintiff. It's my favorite example of show don't tell. I was interning for a judge. We were in the middle of voir dire for what was frankly not that exciting of a criminal case. Half-day trial expected, not salacious details or violence or anything. 75 potential jurors in the room, and when my judge didn't let a guy out of jury duty because he'd have to pick up his kids, that guy proceeded to say in front of everyone that if he was made to show up next week he'd make it the shortest trial ever and find him guilty right out of the gate. My judge was an incredibly even-keel guy. Nothing shook him or got a rise out of him, and he was an expert at figuring out what he wanted to say in the most neutral fashion possible before he said it. Conversations with him took forever because there was a pause before every sentence. But then, this guy poisons an entire jury pool of 75 people. We had to individually question each person to see if that little outburst was going to affect their impartiality, etc. 75 in-camera interviews later, judge pulls the guy back in front of everybody and begins to scream at him about disrespecting him, the courts, and every other juror's time. Me, the attorneys, and the court reporter go white-faced because we didn't know this was coming. The guy didn't have to sit for jury duty, but I still don't know if he got to pick his kids up since he spent a couple days in jail for contempt. This will be buried, but it's a good story, and all. But I represented myself in small claims court against a former landlord in a case of illegal eviction. I was in university at the time, renting a top floor room in a shared dwelling, with 2 housemates on the same floor, and the landlord occupying the basement. We all shared the ground floor, which held the kitchen and living room. One day, landlord come up to my room and tells me I have until 2 p.m. to clear out my stuff because I was being evicted. I had paid rent on time for 4 months, had provided a security deposit, and had never been in conflict with either of the housemates. All told, I was confused. Landlord refused to provide a reason for eviction. So I called the police. The attending officer informed me that he couldn't compel landlord to let me stay, which I expected. I only wanted an official record of what happened on a police report. So I sued landlord for the cost of my security deposit, rent that had been paid for the month I was evicted, the cost of having to find new lodgings on zero notice, the cost of the motel I stayed in until those lodgings were secured. It was midterms, so I had to be in the city to be at school, and damages, all totaling around $3,000. Essentially I doubled my reported costs in the claim. In court it's better to ask for more and let the judge decide what's fair, as long as you don't come off as greedy. Landlord countersued for damages to property, of which there was none. Come the trial, I had all documents, records and discovery, provided by me and to me, from landlord, ready to go. Landlord came with idiot advisor who acted as counsel for landlord, no documents, and one witness. Landlord had tried to convince other housemates to testify against me in court, but they refused. Anyway, the first oh shit moment was when the idiot advisor actually said to the judge that they could do whatever they wanted with tenants, and had been doing so for years, and the judge bench slapped this moron for not understanding the basic tenets of the Landlord/Tenant Act. It has a new name. Can't remember it. The second was when the judge asked if landlord would take the stand to present their evidence, and idiot advisor informed the judge that landlord would not be taking the stand at all in order to plead their case or refute mine. The judge actually said, well, I don't understand how you expect to win without presenting any evidence, but okay. The third moment was when their witness took the stand. He was the handyman landlord called to do little things around the house. He painted the room after I was evicted. In cross, I asked him the cost of painting, less than half off the countersuit, and, as he was called as an expert on the repairs required by the landlord, I asked if in his expert opinion repairs, painting, were necessary. He said no, but he painted anyway, because landlord paid him to. After their witness proved to be a better witness for me, the case was essentially over. The judge asked us to wait a moment as he pulled out a calculator. He looked up from the calculator and stated he found the case in my favor and awarded me the actual costs I incurred, less the inflated damages, around $1,800, which is exactly what I expected. I asked the judge for a ruling on their countersuit, which brought my favorite oh shit moment of the whole ordeal. He said, the suit against you is entirely dismissed, with prejudice, for failure to provide any evidence, testimonial, or something at all to justify this eviction. Landlord is ordered to pay X amount, plus all court fees associated with filing this suit. And after the official ruling was passed, he said to the landlord, I recommend you find a better advisor, because this guy, referring to an advisor, has no idea what he's talking about. It was beautiful. Mine actually happened while I was sitting in the jury pool during voir dire. The case was a double homicide, and the jury pool filled the entire courtroom. If you're not familiar with voir dire, it is when the lawyers ask the potential jurors questions to determine who they want to sit on the jury and who they want to exclude. It is a long and boring process for almost everyone involved, but 9/10 it's the most important stage in a case. So the lawyers are asking us questions, and if that question applied to you, you raised your hand and they handed you a microphone to answer the question. The question asked was, do you or anyone you know have prior knowledge of this case? So this older gentleman raised his hand, is handed the mic, and proceeds to say, yeah, I work at the police station as a janitor, and I heard two detectives talking about him. Points to defendant, and they were saying he was about as guilty as sin. We all kind of stared open-mouthed at this guy, and I started chuckling because I couldn't believe what I was seeing. Naturally, the defense attorney asked to approach the bench, followed quickly by the state prosecutor. After some quick and energetic whispering, the judge addressed the man. Do you realize what you just did? You potentially poisoned this entire jury pool. I will be calling your boss and you will be hearing about this. You can count on that. You are dismissed, sir, but this isn't over. The man was escorted out, and then the judge addressed the remaining jury pool, which was still in a mostly packed room. Now I want you all to disregard what that man just said. I'm sure if any of you were ever accused of a crime like this, you would want a fair trial and not be condemned. Based on the words of one old man, I have been in court many times since, but never have I seen that level of downright jaw-dropping absurdity again. Late to the party here, but as a law student we were allowed to make court appearances under the supervision of an assistant district attorney. I was doing arraignments and my adder said, don't talk to the judge unless he asks you a specific question. So, the judge and the defense attorney were going back and forth about when the next court date would be. The judge wanted a specific date, let's say 4/20. The defense attorney was adamant that she couldn't do that date. In my file, I had a calendar with a big X over 4/20 saying do not schedule. The judge and defense attorney go back and forth for several minutes. The judge wanted 4/20 and the defense attorney saying no. I was keeping my mouth shut because the judge hadn't asked me directly. Finally, the defense attorney relents and agrees to 4/20. The judge turns to me and says, do the people agree with 4/20? At which point I say, sorry your honor, but we cannot schedule for 4/20. The judge looked at me for a second and then just ripped into me, Mr. Jones 1, you just heard me, and the defense go back and forth for several minutes about a date you knew the people couldn't do. Do you like wasting the court's time? It went on like that for a few minutes, him just berating me in front of about 200 people in a court in Brooklyn. Finally, after me apologizing profusely and him giving me a withering glare, we moved on and went to the next case. At the next break, the judge said, Mr. Jones 1, please approach the bench. I thought I was really in for it then. I walked up beside the bench. The judge came down to talk to me and said with a big smile, don't worry about it. I was just giving you a hard time. Welcome to Brooklyn Criminal Court. I've had a couple. Best one was when I was a youth prosecutor / defense attorney in teen court. The youth defendant was on trial for assault. I asked him what happened and he said, my friends told me I wouldn't beat up the Easter Bunny at the mall, so I did. Only time I truly could not control my laughter in court. Another, I was watching a detention hearing in federal court. Only issue is whether the defendant will get to go home until trial. This was an appeal of the court's previous decision that the defendant be held until trial. The third witness was an FBI agent, which, needless to say, is not normal at a detention hearing. The FBI agent testified that some other attorney, not the one representing the defendant at the hearing, had been taking letters from the defendant and sending them to different people for the defendant. Those letters were contracts to have the prosecuting attorney killed. The representing attorney withdrew and the defendant was not released pending trial. One more, I was in traffic court one time and a sovereign citizen who was acting fairly hostile began approaching the judge's bench. He was arrested at gunpoint, which was pretty wild considering there were 150 or so people in the courtroom. Last one, my first ever civil trial. I was representing the plaintiff who wanted to evict the defendant from her property for non-payment of rent. After presenting my case, the judge asked the defendant to present his evidence. The defendant replied, huh. The judge said, now is your turn to present your case. The defendant said, I don't understand. The judge leans over the bench and asks, why are you here? The defendant said, oh yeah, right. The defendant then went on a 30-minute tangent about all sorts of things, like how he only parks his car so he can see where he is going when he pulls out, because that was taught when he was in the military. I could have objected, but the more he talked, the more the judge disliked him. After 30 minutes the judge finally asked about the rent. The defendant says, oh yeah, I'm not trying to debate that I didn't pay it. That's how I won my first civil trial. So, I'm not a lawyer, but I'm a forensic case manager for an alternative to incarceration program. Basically, our program accepts clients who have severe mental illness, and instead of going to jail, they are mandated to mental health / substance abuse treatment instead, and my job is to follow them throughout the mandate and be the point person for the court and their therapists. We go to court with them and talk with their lawyers and judge and provide a psychological evaluation. I have many stories and only been here about a year. This one guy we had to stop working with, even though we initially accepted him into our program. He was eligible for inpatient residential treatment because he was very sick and a violence risk. We referred him to places and got a call from one saying they interviewed him, but they were rejecting him. Why? When asked to describe himself, he laughed and said, "I'm the murderin' type." Yeah, residential facilities don't like hearing that, but point okay. One more. Our judge in our treatment court is really great. He's understanding that clients have relapses, and instead of going straight to jail for violating their plea, he'll give them a warning, or give them more time on their mandate. Usually, when clients are respectful and don't say dumb things. This guy, an old guy, at least 60, charged for selling his meds, comes up positive for cocaine after a couple months of his mandate. Okay, that's fine, we'll work with that. Unfortunately for him, when the judge asked about his urine positive and what happened, he said, "I was out partying, there was drugs, I wanted drugs." No remorse. He was made to go to more intense substance abuse treatment and added time to his mandate. Many years ago I was a puppy lawyer working in the public defender's office. We were in juvenile court defending a kid who had been busted by the cops in the very act of doing about $30K in vandalism damage to a public school. No doubt at all that he did it, and he was charged with varied and sundry crimes which all required proof that the damaged public school building was property of another. You can see where I'm going with this. Everybody knows that a kid doesn't own the school, right? It's plain as can be, isn't it? It went down like this. Prosecutor. The state rests defense. We move to dismiss on the ground that the statutes defining the charged offenses all require proof that the damaged building was the property of another and there has been no evidence introduced to that effect. Point judge. You're right. Case dismissed. Point prosecutor, turning slightly pale as it sinks in. But, judge, visibly angry that this whole kid is going to walk. No, I cannot, and will not allow you to reopen your case. There has been no surprise evidence or trickery here. They haven't done anything but sit there all morning. No, I cannot take judicial notice to supply a needed element that's missing from your proof. We are done here. Case dismissed. Point the prosecutor damned near broke the lectern when he slammed his notebook shut before stomping out of the courtroom. Not a lawyer, but I had to take out a protective order earlier this year against my wife in order to get sole custody of our son during her postpartum psychiatric crisis. She chose to contest the order at a hearing, and she was off the faking rails. At one point while cross-examining me, she objected to her own line of questioning, yelling, "Objection, Your Honor. I'm getting faking pissed off, and I need some crackers. Does anyone have crackers, and can we take a break?" The judge surprisingly granted a short recess and went back to his desk to get her some crackers, but he wasn't fast enough. Before he got back, my wife had run out to the parking lot and slung her hammock in between two random cars, refusing to come back inside. I was sitting on the witness stand when the bailiff came back inside and said, "No sheet, Your Honor. Mrs. Trashcutball 23 is in a hammock and won't come back inside." At this point, the judge lost his composure and started laughing at the absurdity of it all. Hell, I was 2. She did eventually come back inside and yell some more before faking a seizure and going to the hospital. What a day, man. Update. Wide angle lens. During the course of her manic psychosis, which began while evacuating 300 miles from one of this year's hurricanes, my wife was involuntarily committed for 2 weeks at an awful for-profit MHI, discharged without medication access before she was stabilized. Arrested and jailed for 3 days because the state's domestic violence law mandates that EV aggressors go directly to jail regardless of their mental state, and a judge denied my request to have her transferred from jail to her MHI and then released without bond by a magistrate judge who somehow wasn't aware of the severity of her condition. She was then running around for a week and a half with a guy she met at the MHI before the hearing I mentioned. The hearing seemed to be something of a turning point for her. She started communicating with her family more, asking for more photos and videos of our son. A week after the hearing, I took advantage of a significant name typo in the criminal no contact order and a loophole in the no contact portion of the civil TPO to begin communicating with her about potential treatment plans. She started to come down from her month-long manic episode, and about 2 weeks after reopening contact, I convinced her to check herself into an intensive outpatient program at an excellent university hospital. More than a month later, she's getting discharged from the IR program this week. She's stable, she's herself, she's moving in with her grandmother, who lives in the area, and we spent the last week and a half together, the first extended time we've had together since everything went to hell. There's still 6-figure medical bills to contend with, our insurance company is not pleased, as well as criminal charges awaiting resolution, but she and our son are now safe. That's what matters. I've been commuting 300 miles 4 to 5 times a month to keep up with my National Guard and work obligations, but we are starting marriage counseling when I'm back in town next week. When I do something like type it all out, it hits me really hard. We're lucky that we all survived this. We'll be even luckier if our family survives it and stays together in the long term. I'm committed to trying, but we'll see what happens. I have 2 stories that both occurred when I was doing first appearances to determine bail for the public defender's office in my 3L year. One of the guys on the list for an appearance is a regular. He went through our office frequently, and it was always on drug charges. By this time, he knows exactly what happens if he turns himself in. If you show up the night before, you get a lovely jumpsuit for your appearance. If you show up the morning of, you stay in your street clothes. This genius shows up that morning wearing a shirt that says, "High as fuck." About 1 week later, I was doing a quick interview of one of the defendants I was going to represent, and decided I liked him. He was a pretty cheerful, chatty dude. I figured if he kept that up, we'd be just fine and stack up a quick W. We proceeded to the courtroom, and he was probably my 5th or 6th client of the morning. As soon as he got into the courtroom, he began telling the judge why he should be released with no bail. The judge asked him to remain quiet and to let his representative from the PD make his case for him. Immediately, my client starts talking up and down about the First Amendment and his right to speak. I leaned forward to the little hole in the glass box to start whispering at him to shut the fuck up repeatedly. The judge had a hard time keeping a straight face and said to my client, "You should listen to your defender." Unbeknownst to me, the microphone in the box was picking up my frantic whispering, and the entire courtroom heard me telling him to shut the fuck up. Came here way too late for this story to get much traction, but I worked at a small firm for personal injury / med-mal cases. I was going off to Bumble's Lunch Nowhere, Kentucky for a case against a doctor who was pretty negligent of our client's boyfriend who had died in his care over Christmas. We were asking for damages for their 2 kids mostly. They'd been together for 8 years or so, but weren't married. Now, when lawyers tell you stuff shouldn't be a surprise in court, they're right. Virtually everything is filed with the court beforehand, and shit doesn't happen in secret during the trial itself. Usually. In our case, the opposition attorney pulled out some stuffy family law clauses stipulating that there's a legal presumption that if a woman has kids while technically married to someone, those kids are assumed to be the husband's kids, even if they don't live in the same state and had been planning a divorce for over a year. The reason this was allowed, to the best of my knowledge, is that it was part of a last minute motion to dismiss, which doesn't have to be part of discovery and can be filed at any time. Please correct me if I'm wrong. This is limited understanding. Well, you might be able to guess where this is going. Judge doesn't dismiss the case, but jury instructions are amended a bit, and more importantly, hours of trial time are spent now talking about whether or not the kids belong to our deceased man. Long enough that the jury is thoroughly convinced that our clients are fakers somehow. And we didn't have a reasonable amount of time to try to get a genetic test done to prove paternity post-mortem until after the trial had concluded. I've never seen someone caught with their pants down so decisively as this. We hadn't considered that family law would be brought in partially because the couple had been together so damn long. We definitely lost. The kids got nothing except to lose a father over Christmas, and that doctor will go on to be a shitty doctor to others. Not a lawyer, but the assistant DA that was pushing so fucking hard to get me to pay a disorderly conduct ticket. The ticket was for $500, but that'd go on my record, and fuck that. I was working at Children's Hospital and also teaching English as a second language part-time. Both career paths would be faked by that ticket point. Here's why I got the ticket. I asked a guy to pull his car forward 1 car length so that he'd stop blocking the drive. He wouldn't respond to me, so I got up to his car window and asked again. He slammed the car door into my face, breaking my glasses. Then he tried getting out of the car, screaming at me. I held his door shut until he gave up trying. Then I went to call security. Someone else saw it, went and told security. Security calls the sheriffs. I went back to the drive and back to work. The guy accelerates towards me. I barely get out of the way. He strikes my leg with his front bumper. I scream at him, "Are you trying to kill me?" Then took a kick at his car as he passed by. Sheriff shows up, doesn't review the tape, simply writes both of us disorderly conduct tickets. I get a lawyer for $500. I go to court, and he says they should throw it out, no problem. Sheriff's report says exactly what I said happened. We apply to get the video footage, etc. We tell all this to the assistant DA. She says she's going to push it through court anyways, doesn't read the report. We go to court several times for discovery, reschedules, etc. Next time we go to court, we are adamant that we will take it to a jury trial. Fuck it, I'll pay those fees. It's a new ADA this time. We tell him the same sheet. He ain't budging either. Okay, fuck you. Jury time. Let's schedule this sheet, and we do. The judge has even recorded the date and time. After discussing with me when's good for me. She's about to slam her gavel with the ADA rushes over to my lawyer and says, "I'm moving to dismiss." What? He interrupts the judge, says he'd like the case dismissed. Judge looks at him like, "Are you fucking serious?" But she asks, "We've been here 3 times now. We just scheduled the jury trial and he's agreed to all the fees. So why are you moving to dismiss?" ADA asks the judge if she's read the sheriff's report. She says, "No. Why would I have that? Why would I read it yet before there's any reason for me to? Surely you've read it, which is why we've been here this many times. Why don't you read it to all of us?" So he reads the report. It says what happened. The entire courtroom laughs. The judge says, "Ugh, dismissed. Sorry for wasting your time, Mr. M. Just so," while glaring at the ADA, then tells the court clerk to remove the scheduling. Justice Bonner. Not a lawyer, I'm a life coach for former foster kids, but almost got thrown out of the courtroom for disrupting the judge as he was about to award custody of my client's 2 years old to her lying in-laws without even hearing what my client had to say. I had been working with this young woman for over 6 MOs, helping her find affordable housing, stable employment, etc. She wasn't with the baby's dad because he had been physically and mentally abusive, but she really tried to work out shared custody for the daughter's sake. One day, the baby's dad gets arrested on some outstanding warrant while he has custody. He then lies to my client and tells her that child services took the baby. She comes to me in a panic and we call their intake office. They have no record of the child. My client immediately knew what her ex had done, which was to give the baby to his mom and sister, rather than calling my client to come and pick her up. My client calls the mom and sister, who she is not on good terms with, and they straight up tell her, "We are not giving you your baby back, bitch, you'll never see her again." So we get the police involved, and they say there's nothing they can do without a warrant or formal custody agreement to enforce. Then we go to child services, and they do a welfare check. The baby is okay, but they can't return her to mom's custody either, since there's no formal agreement in place. This literally goes on for 2 weeks with me trying to help her get the baby back through legal channels. Finally, we go to court, and she gets a PFA against the guy, thus granting her formal, sole custody of the child. The oh-sheet moment. There were several. First of all, the day we go and get the PFA, we learn then and there that the grown mother and sister have a hearing that day to try and take custody of the child. Their reasoning? They just lied and said that my client couldn't be found, was living under a bridge somewhere and doing drugs, all of which was not true, as I could personally attest from working with her as a helping professional. So, we go to the waiting area, and there is a baby. It's really tense. My client tries to talk to the sister and the lady is basically like, "Stay the fuck away from me." So we go to the security guards, who are actually policemen, and show them the PFA with the custody provision. I shit you not, they enforced it right there in the waiting room, and made this woman hand the baby over to the child's mother. My client cried tears of joy and the baby was clearly elated to be back with her mom. Happy ending right? Not yet. The hearing is still on and the judge has no idea what's just happened. The tip staff advises my client to stay with the baby, even though she's not the one filing the suit. We go in the courtroom and are told we have to sit with the spectators, which makes no sense, while the sister and grandmother sit in front of the judge. We learn then that there's a court-appointed lawyer for the baby, but we have no way of talking to him and explaining how ridiculous it all is. The hearing proceeds, and I get increasingly frustrated because the judge lapped up these women's lies and then very quickly makes move to award them custody. The tip staff sees me getting agitated and looks at me judgmentally, so I'm wondering if my client is going to get a chance to speak. Nope, the judge is just barreling on point. At that point, I had to do something. I couldn't just sit there and watch these liars take legal custody of my client's daughter. I said excuse me, and the tip staff goes, you need to get in line before I throw you out of here. My face is red because I'm really not one to be confrontational, but I'm determined. The judge sees me squirming and asks who I am. I tell him, and I explain who's sitting next to me, the child and her mother. It really was an oh-shit moment, not just for me, but for the judge, the tip staff, the child's lawyer, and certainly for the women trying to take custody. Finally, to my immense relief, the judge lets my client speak, and the truth comes pouring out. And it's not just her word against this. She has texts and call logs on hand to prove she'd been in contact with them the whole time they claimed she was nowhere to be found. It ended up being really good that I was there too. Since I'm a professional representing my organization and thus have strong incentive to be as objective and honest as possible. Within 5 minutes, the judge recants everything he said about giving the grown mother and sister custody and asserts that there's no reason for the child not to be with her mother, presuming the home situation is safe. The case wasn't dismissed completely just then because the judge wanted a welfare check completed on my client's home, but it was dismissed a month later. It was honestly so wild. After this all went down, the tip staff, 40 or so years old man, approached me, 23 years old female, and was clearly flustered. He looked super embarrassed and all but apologized for getting sharp with me earlier. He was just like, great work in there, and then shuffled off. This was a year or two ago, and I recently saw the child's appointed lawyer, who works in a different position now. He was like, do you remember? That was really unlike anything I've ever seen. Bananas. TLDR. Judge almost awarded custody of young child to family members who basically kidnapped her from her mother and then lied about it. The mom and I incidentally find out about the court hearing and interrupt, changing the outcome. I almost got kicked out of the courtroom in the process. I used to work in news. I was operating a press pull camera for a serial rat trial. The victims were giving harrowing and emotional accounts of how this man brutalized them and destroyed their lives. One of the women described how he had strangled her after the rap until she passed out, leaving her for dead. It was all very emotional. After each of the women gave their statement, they would ask the defendant if he would like to respond. Each time he did so by ranting and raving about how his attorney is an idiot and saying that he wants a new lawyer, even after the judge pointed out that this was his second attorney. After one of the women gave her account, he actually remarked, I don't know who this girl is. All I know is that my attorney is dumb, doesn't know what he's doing, and I shouldn't even be here. You need to give me a new trial. Let's stop telling stories about what I did and get me a good lawyer. The guy didn't show an ounce of remorse. He didn't even seem to acknowledge the victims at all. Honestly, he seemed mentally gone from humanity, and the idea of him ever being on the streets of the public was quite chilling. I wasn't there for the sentencing, but I imagine it didn't go well for him. On the other hand, I've seen numerous guys comment that they didn't care about going to prison because that's where all of their friends are, and they missed some of their buddies who were locked up. They seem to just view it as a reunion, not unlike some kind of bizarre summer camp to the rest of us. So I wouldn't take too much comfort in any idea of punishing these kind of degenerates, but at least they are no longer on the street, where they can harm anyone else. Not a lawyer, but a homie who once represented myself in court a few years ago and gave a real attorney a no sheet moment. I received a citation for my backyard pool. I hadn't cleaned it for a month in the winter, and it was greenish. The citation was taped beside my front door, but there was no notice of a warrant. My pool is in the backyard surrounded by a privacy fence. I had not been asked permission to search the property. I wasn't home. In my city, Houston, the municipal code requires search warrants for property inspections, including pool inspections. However, the state of Texas, 18.05e, exempts municipalities of a certain population from obtaining search warrants, which is probably not legal. So I showed up in court to defend myself. The city attorney pulls me aside and explains that she's an attorney and will use that knowledge to defend the citation, including introducing evidence. I tell her I'll do the same, including introducing evidence. Her eyebrows raise, but we proceed. She introduces the citation and calls the inspector to the stand, asking about the inspection. The inspector describes her visit, culminating in the citation. When it was my turn, I asked the inspector if she obtained a warrant. She said she did not. I quoted for her the relevant section of the municipal code requiring her to get a warrant and asked her why she had not done so. At this point, the city attorney asks for a conference, and the judge pulls us up. The city attorney duly notes that Texas law trumps Houston municipal codes by not requiring search warrants for municipalities of its size. The judge turned to me, and I said, well, if she's going to use Texas law to trump local law, then I'm going to use federal law to trump Texas law. In the Supreme Court case of Camara v. Municipal, the Supreme Court explicitly stated that it has nowhere been urged that fire, health, and housing code inspection programs could not achieve their goals within the confines of a reasonable search warrant requirement. Thus, we do not find the public need argument dispositive. Thus, the Texas law is unconstitutional and a search warrant is required. The city attorney's jaw dropped, and the judge quickly dismissed my case. But then the real sheet moment happened. The next few cases were all pool inspections, and none of them had used a warrant either. So the judge conferred quickly with the city attorney, then dismissed those cases without even hearing them. Edit. Added links to the laws in case some lawyer/homie wants an easy win. When I was articling, I walked into a courtroom where a trial was already underway. Defense counsel was conducting an examination of her client, the accused. The judge was breaking and entering. I sat near a lawyer who wasn't involved in the proceedings, who I kind of knew. He whispered to me that he was only there to watch because defense counsel had such a bad reputation. During the time I was there, I watched her ask leading questions constantly. In examination in chief, you're not supposed to ask leading questions except for very basic things. Eventually the prosecutor got fed up and stood up to object. The judge agreed and warned the defense counsel to quit with the leading questions. She said okay. She immediately resumed asking leading questions. The prosecutor started to stand up again, but before he could lift his butt off his seat, the judge looked at him, held his hand up, and said I know, and again cautioned the defense counsel to stop with the leading questions. She was really stumbling after that, and as she continued asking questions, she basically got the poor guy to admit that he had broken into the house. His own lawyer got him to admit his guilt on the witness stand. The lawyer I was sitting beside was visibly squirming in his seat at this point, and my eyebrows were as high up on my forehead as they could possibly go. Anyway, things continued. The guy was found guilty and the judge gave him a very light sentence. I then had to do my own stuff with the court, and because I was a brand new baby lawyer, the judge invited me to chat with him afterwards. I told him that I was surprised by the light sentence in the previous trial, and he said I couldn't punish him for having a bad lawyer. I do court-appointed criminal work. I don't get to pick the client. I play the ball as it lies. Had a client charged with child molestation. He basically bribed a kid with trading cards to jerk him off. Minimum 25 years up to life in prison if guilty. Also charged in a separate case with massive financial crimes. We are not appointed to point anyways. I explained to him the penalties the prosecution has controlled. Calls where the kid talked to the defendant on the phone about it months after it happened. One party consent state, and the defendant gave religious explanations as to why he put this in his past, and said the kid should do the same. Evidence is pretty bad. Point state offers 25 years. He could get 30 on the economic offense alone, followed by no probation. Dude wouldn't budge. He wrote us lengthy letters with biblical verses explaining, I guess, that God would miracle his ass out of a prison sentence. We had him evaluated for competency and he passed with flying colors, so we take depositions and go to trial. Guy has no criminal record, so if he wants to take the stand and say it didn't happen, why the hell not? We had no other defense, really. So he shuffles up to the stand. He doesn't carry himself well. He is 5'6" and 150 pounds soaking wet, and proceeds to say that the kid came up to him and offered to jerk him off, and even showed him Zamster.com and offered to watch videos with him, and it was the kid's idea. Statutorily this is not a defense. He just took the stand and confessed. The bailiffs had over/under on a verdict at 10 minutes. Still, they had a question and asked for the call to be replayed. An hour later, guilty. I presented all manner of medical evidence of the guy being ill. He has manuscript, diabetes, etc. Judge didn't care. Life in prison. Whelp, that's how that goes. Attempted murder trial last summer. I'm representing the defendant. Prior to trial I was reviewing the transcript from the preliminary hearing. At the prelim the detective testified that the gun used to shoot the victim was a semi-automatic pistol with a specific size barrel. This was important because the defendant had a prior conviction that prohibited him from possessing most firearms, including semi-automatic pistols with barrels under a certain length. The gun was never found during the investigation. 5 shell casings were found at the scene and sent to the state police lab for analysis. I read the report prior to trial, which said all 5 shell casings were .22 caliber and fired from the same unknown firearm. I've seen this state police firearms expert testify before. He knows absolutely everything there is to know about guns. I knew that if he could tell that the gun that ejected those casings was a semi-automatic pistol, or that the barrel was a certain length, he would have put it in his report. At trial the state police expert testified. He went over the intricate analysis with all the high-tech equipment he used, think the car expert testifying in My Cousin Vinny, to come up with the conclusion that all 5 casings were .22 caliber and were ejected from the same unknown firearm. I asked him, can you tell the type of weapon that fired these rounds from your analysis of the shell casings? He said no, he could not. I asked him if they could have been fired from a semi-auto pistol. He said yes. I said, how about a revolver? Or a rifle? He said yes and yes. I asked if he's able to tell the length of the barrel of the gun that fired those rounds. He said no. Then the detective testified. I asked him if he remembered testifying at the prelim. He said no. The district attorney looked at me and rolled her eyes. She had already admitted the prelim transcript into evidence, the transcript which contained the detective's testimony. This was my first oh shit moment. Clearly the detective was underprepared for trial. I handed him the transcript and asked him to review it. He did, and he said he remembered it now. I confirmed, at the prelim, you testified that the gun that fired those shots was a semi-auto pistol with a specific barrel length, correct? He said yes I did. I then asked if he heard the state police expert's testimony. Of course he did, he was in the room. I just wanted to remind the jury what the expert said before about the intricate analysis and high-tech equipment he used, and he couldn't tell the size or type of the gun. Detective said yes. I confirmed, and you never found the gun, did you? He replied no, they never found the gun. That's when I dropped the bomb. Then how were you able to tell the size and type of gun that you've never seen solely from the shell casings when this state police expert who had all this fancy equipment couldn't even tell? Long pause. I guess he knows more about guns than I do. Oh shit. Not guilty. All counts. After trial, the judge spoke to the jury. I heard through the grapevine they told him they thought the detective did a bad job investigating the case. To those of you that don't understand the significance of this oh shit moment, at the preliminary hearing the detective testified under oath that the gun was a certain type and certain size. You take an oath that you will tell the truth, The whole truth and nothing but the truth. The fact that the gun was a semi-auto pistol and had a certain barrel length was not the truth, because there's no way he could have known that. So to the jury, it looked like he lied under oath at the prelim. When I was a law student, I had a client accused of assault. He got out of his car and started punching some 10-year-old kids unprovoked. My client denies this. He claims they threw rocks at his car and he only pushed them in response. This was all in broad daylight and the prosecutor has like a dozen witnesses. A trial date is set. As it approaches, I negotiate an agreed statement of facts with the prosecutor. My client will admit that he pushed the kids after they threw rocks at his car. I discuss with client and he agrees. Because we've agreed to the facts, the prosecutor drops all of his witnesses, so my client is getting the facts he wants. Unfortunately, the facts mean he is still guilty of assault. But we discussed this, and he understands and accepts this. The morning of the trial arrives. I meet him at the court house about an hour before to go over everything one last time. He show up with his 16-year-old son, his other legal advisor. His son tells him he has to fight for his day in court and that only the truth will set him free. This is very confusing, because the facts he is admitting to are my client's version of events, word for word. At this point my client's not sure who to believe, because we both make some pretty good points. I'm trying to impress upon my client that he goes back on his word. The prosecutor, who cancelled all of its witnesses in reliance of the agreement, will want blood. We get into court. Court asks my client how he pleads. Client stands up. Not guilty, Your Honor. I slap my forehead. 2 seconds later. Sorry, Your Honor, I mean guilty. As he had a clean record and the facts were very favorable. Judge gives him an absolute discharge. He got off consequence free. Note, I haven't done criminal law since I was in law school. Some of the words/terms I have used might be a little off. Sorry. This happened when I was interning with our city's district attorney's office. Defendants were being arraigned on a variety of small-time charges. This was an all-morning court session where people were brought in that were arrested the previous day and were given a chance to basically hear what the charges against them would be. In some cases there would be a plea for guilty or not guilty, bail would be set, etc. Most of these appearances were over and done within 10 minutes. Almost everyone is using the public defender. This one person gets called up. He looks like an average middle-aged man. He does not speak English, and he speaks an unusual language. I think it was a Slavic language or maybe Polish, I can't recall. It was unusual enough that the court did not have a court interpreter for him. He had sort of brought his own interpreter with him, though. It looked like a friend or a relative. The judge gave instructions to this interpreter on what he was supposed to do as an interpreter. Basically, you are to repeat, word for word, exactly what I tell you. When he, the defendant, speaks, you are to repeat exactly what he says. Public defender is standing by. Okay, let's get this done. Judge asks the defendant his name. The interpreter talks to the defendant. Then the defendant starts talking back to the interpreter, and it's very quickly apparent that the interpreter is not simply relaying the judge's words. They are having a back and forth conversation. The judge interrupts and makes them both be quiet. He instructs the interpreter again. The public defender with them talks to the interpreter and basically tells him you need to only say what the judge tells you to say. Okay, everyone understands. Let's try this again. Please tell the court your name immediately. The defendant and the interpreter start having a back and forth conversation again. The defendant is obviously not saying his name. He's obviously asking the interpreter all kinds of questions, and the interpreter is obviously trying to answer them and is not doing what he's supposed to. Judge stops everyone again. He tells the interpreter again, pretty sternly, listen, he needs to state his name for the court. If he will not do that, we cannot proceed. Do you understand? The interpreter says yes he does. Public defender pleads with the interpreter to do what the judge is asking. Please tell the court your name. Immediate. Back and forth conversation. Judge says, okay, he can stay in jail for the day. Next. Public defender face palms. I was doing pro bono work as a guardian ad litem for adult guardianships. In that role the attorney serves as the eyes and the ears of the court. You prepare a report for the judge in the case. Usually it's about a potential guardian and a ward, and whether you think guardianship is a good idea. This was a case of someone who was already a ward. She was fairly independent. Oftentimes the ward has no job, no source of income aside from social security, and is demented to the point of being bedridden. This ward was mentally challenged, but was able to hold a part-time job and live separately from her family. The ward and the guardian weren't getting along. The guardian was supposed to file an annual financial report, but instead delivered a form with a bunch of blanks and some scribbling about how the ward was being difficult. So, I got asked to investigate. It was family trouble. The mom had guardianship of an adult daughter. The mom hated her daughter's new boyfriend and took every opportunity to tell her so. The mom was very religious, and I think any premarital relationship was out of the question in her eyes. In retaliation, the daughter refused to give her pay stubs to the guardian. The guardian needed them to file the annual report. The day of our proceeding came. Mom, myself, and daughter approached the judge. I delivered my very dry report about a minor family dispute. I suggested the court order family counseling or some such to smooth out the grievances. Then the mom launches in. Keep in mind, this is the guardian, not the ward. This is the person who is supposed to be level-headed and watching out for the person who can't watch out for themselves. Your Honor, I have something very important to tell you. There is a crime being committed. Mr. Hinuban and my daughter's boyfriend are engaged in a scheme to prostitute my daughter. From there she launched into a detailed, lengthy, paranoid screed about how the boyfriend had convinced her daughter to change hairdressers. The daughter now went to the boyfriend's sister's hair salon. The new haircut she had was one specifically for prostitutes. I had given a report without these important details because I had been promised a cut of the profits. My face was bright red. Looking back, it's funny, but being accused of taking advantage of a mentally challenged girl in order to pimp her in an open courtroom with somewhere between 50 to 100 people was mortifying. It's a very formal place. It gives even the most insane allegations of an air of credibility. A stenographer put that into the record. The mother had not told me any of her suspicions. She had been very polite, if a little cold, during my visit. The judge knew me. She told the guardian she thought it was unlikely and ordered counseling. ELDRI was accused of conspiring to pimp a mentally challenged person. This was during my first jury trial, after graduating law school and starting with a firm. Something that is important to know for this story are there are essentially two sides to a courtroom in a jury trial. The court when the jury is present, which is formal, rule-based, and very measured, as opposed to the courtroom before or after the jury is called/released, which is much more laid back and relaxed, if those terms even make sense. Anyway, as some guys will know. Going to the bathroom to pee, you have a little ritual to make sure everything is zipped up in where it should be before leaving the bathroom. I was nervous, but I didn't have to pee. I just wanted to make sure I was all tucked in and my suit looked okay before heading out there. This was my mistake. I get back to the room. Everyone is ready for the judge to call the jury in, which he proceeds to do. So we have about 30 seconds before the jury makes it from their back room to the court. Suddenly, the judge urgently looks to me and says, "Counselor, approach the bench." I head up there, not knowing what to expect, and my boss is close behind. The judge looks at me and says, "You've got about 15 seconds to zip your fly before the jury gets here, and I'd suggest you do that." I've never been so red in my life. Luckily, I won the case and walked away with a memory to laugh at rather than beat myself up over forever. That's my story. Hopefully nothing beats that for embarrassment as I go through my career. Not a lawyer, but as an employee of landlords, represented them in court. Probably 80 or so times landlord/tenant cases were heard at a certain time each day, and during the busier time of the month there might be 20 or 30 of them scheduled. So oftentimes you would observe many cases while waiting to get called up. Once an old dude, small time landlord, had changed locks on the tenant, a college kid, out of his house and was trying to retain possession of his belongings as revenge for unpaid rent. The judge got really pissed off because of course this is illegal. I don't remember what exactly the outcome. I think it was probably continued to another date. My case was called up immediately following. My defendant didn't show up, and the judge cracked some sarcasm about why I didn't just change the locks and take his stuff like the last guy. One time we were evicting a young couple who had some mental health issues. They argued a lot, but the main issue / craziness was the woman, who would threaten to cut kids up at the pool. Our case gets called up to the stand and just the woman is there. A few minutes into it, and the guy shows up and says that she pushed him out of the car on the way to court. The sad thing was, the judge ordered the guy out of the apartment that day and gave the woman the whole week. Typically they give everyone a week. 95% of the crazy was the woman. One more story. Another young couple who had been warned several times about marijuana, illegal here, illegal pets, neighbor disturbances / noisy arguments. Finally get evicted. They were very loud and argumentative. The judge ordered the guy to go sit down because he got really loud. The bailiff had to grab him and then told the girl that she can thank her boyfriend for the eviction. I'm not a lawyer, but one of my oldest friends has a great story that I'm going to steal for internet points. Fresh out of law school, my friend, Hiro, wanted to primarily focus on cases of civil rights violations, and so he was working somewhat freelance and having cases referred to him that other attorneys decided not to take for one reason or another. For his very first case, he was referred to a client that was suing the NYPD for assault and violation of due process under the Fifth Amendment. The plaintiff was a young man who claimed to have been beaten by the NYPD while being held without being charged, and the trial was set to begin a week after Hiro signed on. He spent days writing an impassioned opening argument to the jury, highlighting the injustices experienced by his client, while railing against the corruption of the police department in their attempts to quash his client from speaking out. He practiced his delivery, perfecting his intonation, and nailing all of the emphatic points. When the trial began, he was confident and ready. He delivered his opening remarks, just as he had practiced, with the emotion and fervor necessary to rouse outrage amongst the jury that such an injustice could be visited upon a fellow citizen by the heavy-handed police. When he finished, he sat, letting his remarks linger in the ringing quiet of the courtroom. Then the city began their defense. Apparently, the plaintiff's injuries were suffered because he, while drunk and high, grabbed the steering wheel of a car traveling 70 miles per hour on the West Side Highway, causing the vehicle to crash into a tree and nearly killing the driver. When the ambulance arrived on the scene, the plaintiff instigated several fights with the paramedics, who he believed were trying to kill the driver. He prevented them from administering any kind of aid as he kept screaming that he alone could save his friend. Fortunately, the police arrived shortly after the ambulance and subdued the plaintiff, allowing the EMTs to effectively save the driver's life. This was the first time Hiro had heard this version of the events in question. He then requested a recess and recommended his client pursue a settlement rather than continuing with the trial. It's not as good as most stories on this thread, and I'm no lawyer anyway, but still want to put in my limited experience. I'm sorry if I put some terms wrong. English is not my native tongue, so I'm not sure if use terms like prosecution and attorney correctly. I received a speeding ticket. In Europe you have tons of speeding cameras. You can get the ticket without ever being stopped by a police officer. The date on the ticket was a date when I was out of the country and my car was parked in a parking garage of an airport. Clearly a mistake. Asked for the picture, and it's the same type of car with almost the same license plate. Understandable mistake as well. Of course, then starts the Kafka-like process of getting the fine withdrawn. You can reply to the fine saying you don't agree, so I did, pointing out that the car on the picture was not my car as the license plate is different. I got back an automatic reply saying request denied. I'm sure no one ever read or saw my letter. At this point, the case can go to court, but you are expected to put in some kind of rudimentary reason why you take it to court. Again, I put in a copy of the picture and a copy of my vehicle registration, showing the license plates do not match. I fully expected someone to read this before the case actually went to court, but apparently didn't happen, and I got a court date and all. As I thought this was all very funny and an easy case to win, I just went there, didn't bring an attorney or any other legal help. The case starts, the judge explains why we are there, and gives me the chance to explain why I think I shouldn't have to pay the fine. So I start with simply saying I didn't speed. Of course in my head I would follow this up immediately with explaining that it is not my car in the picture, and that I was out of the country at that time. But the judge did not give me that chance. Probably had a long day of all kind of traffic violations that stupid people who are clearly guilty still try to deny. He immediately asked me, so, you never speed, ever? And I was flabbergasted by that question. Of course, being in court for the first time, I was nervous as well, so I just stuttered that I was not speeding at that specific time. So you do speed sometimes. At that point I was certain that I, the greatest idiot alive, would manage to lose a case where I had evidence in hand that it was not my car and that I was out of the country anyway. The judge simply wouldn't allow time for me to explain the case. I managed to stutter something like I wasn't even there at that time, and the judge goes over to the prosecution. I really felt my chance had passed. Prosecution really doesn't say much. Judge looks at his paperwork and asks me, I read here that you were out of the country at the time of the speeding ticket. Can you elaborate? And thank God, I managed to pull myself together. I explain that the car on the picture is not my car, as anyone who can read will see, and that indeed, I was out of the country at that time. See plane tickets here, hotel booking here, parking ticket from airport here, see picture of speeding offense here, and my car's registration here, all in his files. The judge starts to laugh and asks me why on earth I didn't say that the first time. He explained that everybody just says they did not speed. That is not a good way to start a defense. If you actually have a case point, of course. The prosecution had little to say about all this. The fine was withdrawn, and I even got some money for the time it cost me to go to court. But next time I will go to court, no matter how trivial the case, or how sure I will win, I will take someone who has professional courtroom experience. I posted this a year ago under the title Foghorn Leghorn Esquire. Notes: my cousin works for the court in the deep south. This is his funniest courtroom story, albeit a horrible case. I'm recounting it to the best of my memory. Point prosecutor: after he beat you, please tell the court what happened next. Point victim: he bent me over the sofa and entered me from behind. Point P: he entered your vagina forcefully from behind. Correct. V: tears: yes, that is correct. Point P: the state rests. Your Honor. Judge. Defense: your witness. Defense stands up, looking overly confident. For the record, you have stated that my client entered your vagina from behind. V: sobs: yes, that is correct. D: and you are certain that it was not from the front. V: yes, I'm certain. D: you mean to tell this court that my client entered your vagina from behind you? V: yes, Judge. The victim has made it clear that she was wrapped from behind. Please move on. D: sir, I say sir, I was just verifying her accusation. Point J: don't ask that question again. Continue please. D: understood, Your Honor. Now you have claimed that my client entered your vagina from the rear. But how is that possible when it is a fact that the vagina is on the front of a woman's body? Big smile, very proud of himself. Judge. Victim: what? Prosecutor: objection. I think. D: how could my client have entered your vagina from behind when the vagina is on the front of your body? V: confused. The vagina is kind of in the middle. Point D: what do you mean? V: it can be entered from the front or the rear. D: shuffling papers. 1 minute. Judge. Does the defense have any more questions? D: J: any questions? Defense. D: exasperated. The defense rests. I was a legal intern in child support court, working for the state. Our job was primarily to meet with the parties, usually the parents, and try to resolve their child support disagreement/renegotiation through a mediated settlement. If the parents couldn't resolve their disagreement or agree to a new child support amount with us, they would go in front of the judge and she would decide the new child support amount based on evidence presented by each side. One father told us he could not afford any child support and shouldn't have to pay anything because he bought his 15-year-old child basketball shoes a couple of months back. Okay, so they go in front of the judge. The father is arguing his case, calling his ex-wife and his new wife as witnesses when his cell phone rings loudly. He asks the judge if he can take the call. The judge says no, of course you can't. Father says well, it's her, points at ex-wife's house calling and picks up. He then proceeds to have a phone conversation with whoever is on the other end. Everyone is shocked. I think there were audible gasps. My boss sends me to the hall to get the bailiff. He hangs up. The judge is furious, gives the guy an impressive lecture on respect and court rules. He gets defensive, does not apologize, and continues to try and argue his case re child support like nothing just happened. Judge completely loses her temper, holds him in contempt of court, and he is arrested by the bailiffs and led out of the courtroom in handcuffs. That was the day I decided family law was not for me. Obligatory not a lawyer. When I was 16, I was on vacation at a state campground with some family friends and a girl, we'll call her A, who we'd met the year before, and her family. There's not really much to do, it's pretty secluded, so at night we would just roam around the campground and engage in various shenanigans. It's about 10 PM the first night. Me, 3 of my family friends and her are hanging out by the playground in the middle of the campground, and A's dad, abusive alcoholic, we'll call him X, drunk at the time, comes by and tells her it's time to go to bed. She resists because it's early and we had just gotten there a few hours ago. It escalates. He ends up punching her in the face. He runs. The state police end up tracking him down and arresting him. They take our statements. She ends up leaving the campground and going home with her mom. Fast forward 2 years, and I'm called to testify about it in court. X's lawyer was trying to paint the picture of misunderstanding, where X was just a concerned father worried about his 16-year-old daughter hanging out with 4 hoodlum guys. The lawyer was doing a decent job trying to paint me as some asshole kid, until he started asking me about my relationships to my family friends. He traverses down the list and finally asks me about how I came to meet the last of the 3 friends. I explained how we'd met when we were in the same bereavement counseling group after my brother was killed when I was 6 and his brother was killed when he was 5. Since then our families have helped each other run charitable foundations in honor of our brothers, and we vacation together as well. The lawyer's jaw dropped and was quiet for a few seconds before saying, I'm sorry for your loss. No more questions, Your Honor, and sat down. Needless to say, they lost. Former prosecutor, I've had a lot of instances of these oh shit moments in court, but here are a few that stand out. Defendant at sentencing for minor misdemeanor case doesn't recognize the judge's authority to hold power over this individual, so he continues to yell things at the judge, like I don't recognize your power, so you can't make me do shit. His 10-day jail sentence came with a 30-day contempt sanction. Had a defendant obviously on drugs try and steal another person's phone while in court on theft charges. The sheriff deputy found him in the bathroom with his pants unzipped as he was tucking the phone into his underwear. They handcuffed him and walked him back into court without letting the man re-zip his pants. By the time he was in front of the judge, his pants were around his ankles. DUI case, where the victim on a motorcycle was hit by the drunk driving defendant. Defense's main witness claims the victim was riding at night with his headlight off. Victim is riding a Holly. On cross, the witness admits the bike she saw wasn't a Holly, but a street bike. The question I asked was a bit of a throwaway, because it didn't occur to me the defense attorney hadn't asked her the type of bike she saw. After pressing the witness, she admits the bike she saw wasn't a Holly because her dad rides one and she knows how loud those are. Everyone in the courtroom got a surprise on that answer, not a defendant or witness, but the defense attorney. End of a trial. Jury is headed to a hung jury because one juror is refusing to come to a decision due to mental health issues. The jury asks if they can come back with a 5-1 ruling. I object and say it isn't constitutional. The defense attorney convinces his client that a 5-1 ruling is in his best interest, finds one case from the 70s where something similar happened, and has his client enter a 20-minute discussion with the judge about giving up his constitutional rights to a 6-person jury verdict. The defense attorney is a public defender, and getting this through the court was the hardest I've ever seen him work. The jury came back 5-1 guilty. Saw a public defender getting questioned by a judge about why a case was not ready. The defense attorney responded, "Because I'm a bad lawyer, Your Honor." He said this in front of a full courtroom of attorneys. Also now about a law student. There was one case where a guy was accused of assaulting a police officer at a left-wing protest. The victim police officer stated that he didn't even notice the assault because he was wearing riot gear. He was supposedly hit in the head while wearing a helmet. The footage from the police video surveillance had been accidentally deleted, so it was basically just the testimonies of other police officers that supposedly saw the attack. First of all, they all independently claimed that the attack took place over half an hour before it could have happened. We had proof the client only arrived at the protest at a certain time. Then one of the police officers kept referring to the defendant's name during his testimony, like I saw client's name at XX doing Y. The judge started to get skeptical and asked, "How do you know the defendant's name? Did you make a memory protocol that you reviewed before your statement, or are you citing this from memory?" The police officer goes, "Well, we logged into the case files and read them before coming here." Everybody in the courtroom goes silent because obviously it's not allowed as a police officer to log into police files and read them before making a statement. The judge is obviously surprised and goes, "So you logged into these files at your workplace and read them before coming here?" At that point the prosecutor actually says to the police officer, "You don't have to say anything that potentially incriminates yourself," but somehow the guy's too thick to get, and it says no. A colleague sent them to me via WhatsApp. The defendant was actually later cleared of all charges. Less than a year out of law school, the DA asked me to sit in on something without much warning about what was about to transpire. I assumed they needed an extra witness for an adoption hearing or something, since it was a closed proceeding. So I walked in, sat down on the back bench, and after a couple of minutes our entire compliance department personnel soon followed and joined me in the back. As the judge walked in, one leaned over to me and whispered, "Do you know why we're here?" I shrugged and shook my head. My boss stood in the center of the courtroom and an elderly woman in her mid-70s was seated in the witness stand. There was a court reporter present, but no real indicator of what was about to transpire. When the judge was seated, my boss introduced the lady in the witness stand and said that he wanted to make a court record of what she was about to say. He asked her to tell the court about what brought her to the courthouse that day. On the back row, we all exchanged perplexed glances. She started by stating her name, the day of the week, where she is employed, etc. Then my boss asked her about a crime she wanted to report. This was highly unusual. I was racking my brain to think of why they would want to take a crime report in such an unorthodox and inefficient manner. I half expected the judge to be pissed off about wasting the court's time. Then my boss asked what it was that was stolen from her last night, and she exclaimed, "My vagina. And my uterus too." She then proceeded to retell a sequence of events that she said took place after she went to bed, and accused her neighbor of the deed. My boss asked why her neighbor would do such a thing, and she replied, "Well, because hers is all dried up." As if it was so obvious that asking the question was ridiculous, the judge told her these were serious charges and that they would need to escort her to get checked into the hospital while they investigated the crime because her health must be at risk after being the victim of such a violent crime. Then he signed an order for a 5-day mandatory stay at a mental health facility and she complied. Apparently she had a long history of these kind of accusations. Her family had tried everything to get her to get treatment, but she wouldn't go. They worked something out with my boss and the judge when she started accusing someone again. Weirdest day in court ever though. This will be buried, but it was fun for me. I was on jury duty. Long and short, the case was about a man who had been living in his vehicle, not an actual residence. He was on a list and was required to report his whereabouts regularly to the PD. He moved his vehicle, then stopped reporting. The prosecutor had mentioned at the very beginning the stipulations of the case, including that the defense agreed that he was supposed to be reporting in based on his temporary living situation, but buried it in with a ton of other stuff. We the jury were inundated with testimony, opinions, facts for most of the day. Nearly everyone had forgotten the stipulations. Most of the jury were hung up on the definition of temporary housing. Myself and a couple others argued that it didn't matter, as he had known the rules, signed that he agreed to them, followed them for months, then suddenly stopped following. One juror stated that she didn't remember that fact, so I asked for us to review all the documentation prior to bringing our decision. We were brought back in and allowed to review the paperwork. I was waiting my turn to look at the documents, looking at the defense lawyer. She looked so smug. Then one juror before me asked to see the stipulations document a second time. The defense lawyer's face dropped immediately. There was no more debating. He had agreed to his position prior to the case. He knew he was supposed to be reporting and signed documents stating so. The prosecutor just never brought it up, except once at the beginning, buried in a host of other jargon. The judge popped into the jury room after we were done to dismiss us. He told us that the defendant was on the list because he had sexually assaulted a little girl, and that this was not his first time attempting this, not reporting his whereabouts. Because of our decision, he would be incarcerated for a long time. Felt good that we made the right decision and literally didn't allow a criminal back on the streets. I'll never forget that lawyer's face, though. A workers' comp case was set for trial. Employer, represented by me, versus the state. Benefits for deaths without dependents go to the state of California. The state's sole witness was John Doe, a former co-worker whose testimony was supposed to help establish that the now dead employee was stressed and that the heart attack that killed her happened at work. When I saw Doe's name on the witness list, I mentioned to opposing counsel, this is not a good witness for you, and you might want to consider taking the six-figure settlement offer on the table. Instead of asking me what I was talking about, she snapped, "Don't tell me how to do my job." On cross-exam, I asked him if he remembered ever previously talking to me. He did not. I had taken John Doe's deposition 3 different times on his own case. I presented the transcripts and asked if that refreshed his recollection. It did. Now he remembers me. At this point I offered to give opposing counsel a new copy of the transcripts, earlier served, but obviously not read, and stated she could have a continuance if she wanted. Again I get, "Don't tell me how to do my job." Me. John, at the beginning of your testimony this morning you stated under penalty of perjury that you were not taking any medications. Is that true? John. Giggles. Me. At your last depot you were taking over 20 medications. Have you stopped taking any of these? John. Giggles. Me. If you have stopped taking any of these meds, please let me know. I then slowly list each medication, pausing for effect after each one, and continue. He not only hadn't stopped taking any of the medications, but was also now taking a few new medications, which he could only identify as the pinks and the reds. He also refused to say where he got the new medications. The judge disregarded Doe's testimony, and I got the easiest and most undeserved win of my career. I fully expected a call from opposing counsel trying to accept the settlement offer, and also expected an appeal, but they just rolled over on it. The lesson is, maybe read the documents put forward by the other side before trial. And all but I was suing an ex-boss for on-the-job injury. Scum didn't pay his workers' comp. Shocker. His lawyer showed up to our first hearing himself. Big dude, like 6'5", got very physically aggressive with me without touching, trying to bully me into settling for less than one half my hospital bill. I was only 18, but even I knew at the time that this jackass wasn't going to throw down in the goddamn courthouse. Trial day comes. Instead they send this super hot early 20s female lawyer, assets hanging out, that tries to flirt me into settling. I enjoyed the attention, but didn't commit to anything. As we move into the courtroom she gets aggressive as well, shows me this huge stack on paperwork saying, "Look at all the evidence we have, that this was your fault. It wasn't. You're not going to get a penny. I'm trying to help you etc. I put her off with, "Wow, yeah I see your paperwork, etc. Still no commitment. Once the judge sat, he asked if a settlement had been reached. She looked at me all smiles, and I said no, I have not agreed, and would like to proceed. I was a kid, and didn't know better, so I wrapped myself. She went full deer in headlights. The paperwork was all fake. She didn't even know the basics of the case. She tried to BS through it, but the judge was having none of it and gave me the maximum point at it. Reading this through it can come off a bit of I am very smart. That is totally not my intention. The case was super simple. The guy had us using inferior equipment and tried to get me to lie about it being a work injury. I basically sat there, answered a couple questions from the judge, and he lowered the boom. Now but the plaintiff point my ex-husband attempted to kill me. He had made a call to a government agency that records calls and told them that not only had he physically attempted to kill me, but that he also planned to return to the home and kill me. They contacted the cops, who responded within a minute point in court. Several months later, where he was being charged with felony battery, he denied all charges. The judge reminded him that he admitted to everything during the call, which they had the recording/transcript of. My ex replied that the call couldn't be used because it was hearsay. The judge asked him why he thought it was hearsay, and my ex replied, because they heard me say it. Later on, after I filed, he contested the divorce. At court, when the judge asked him why the divorce shouldn't be granted, he claimed I forged his signature on the divorce papers. The judge saw that I filed for divorce through publication, since I did not know where my ex was living. The judge then explained that I did not forge a signature because I didn't need a signature. My ex then told the judge that there can't be a divorce if he didn't sign anything. The judge told him that wasn't the case, but regardless, the court wanted to know his grounds for contesting the divorce. My ex said he wasn't contesting the divorce, he just wanted the judge to know I forged his signature on the divorce papers so I could be put in jail. The judge told him in the future not to waste the court's time and granted the divorce point. On the way out of court, my ex followed me and accused me of trying to get him arrested for breaking the no contact order by filing for the divorce. I was a witness into a horrible crime, which I've talked about previously here on Reddit. The defendant was a repeat offender. He was facing 1 count of rap and 1 count of kidnapping, and if these charges went to a full-blown jury trial, he likely would have gotten the full 25 life sentence with no chance of parole. There was a good amount of physical evidence. The statements the victim and witnesses made were all consistent, and he was going to be facing separate charges for possession of child pornography in another county, so he's not really in the position to do anything bold. His attorney got him a plea deal of 19 years in prison, of course with all the usual extras of being registered as a sex offender, but it was 6 years less than the minimum, and a hell of a lot better than dying in prison, though 19 years is still a long time for child molester. I showed up to the hearing for his plea deal because I was allowed to make a statement on the victim's behalf if necessary. Of course, I'm sitting here with the prosecutor and legal counselor as we're all thinking he's just going to take the deal and not be a problem anymore. He walks in, the judge presents the case, the charges, and explains his rights. She clearly goes over everything that would come of both a trial and what the plea deal means. All he has to do is say yes and get sentenced. At this point he hesitates. His attorney asks him to speak clearly and answer the judge. At first we all worry that he's going to take his chances with a jury trial, which no one really wants. But then he goes one step farther into stupid than anyone expected. He asked if he could fire his court-appointed attorney and hire a new one to get a better plea deal. Courtrooms are usually pretty quiet. This one was not. We heard shocked gasps, the judge stifle a laugh, and his attorney's jaw hit the floor. Ignoring the fact that this guy didn't have the money to hire another attorney, how did he not understand that the plea deal is a one-time thing? If he did anything other than take that deal right then and there, this was going to trial. The prosecutor straight up told the court that and said we were prepared for fight for the maximum sentence just because she didn't want to put a 12-year-old on the witness stand for such a horrible crime. This dude was persistent though. Even after it was explained by 2 lawyers and judge that he absolutely wasn't getting another plea deal, he was still fishing for something that would get him out of this. Eventually the judge asked he be taken away, have everything explained to him, and come back when he was ready to take the plea deal seriously. Fortunately he came back and took the deal. I read the victim's statement, and he was sentenced 19 years in prison and maybe more after the pornography case ends. That moment though, when he said he wanted to fire his attorney in court, that was so unreal. I felt like I was in the cheesiest movie of all time, except it was real and the guy saying all this really deserved a high five in the face with a brick. This'll get buried, but still a good story point. I was the defendant in a case where I was accused of hitting a teacher with my car, which was true, but the details get a lot hairier. So I grew up in Winston-Salem, North Carolina, where we had a school in which you could take classes that weren't offered at your normal school, provided you had a means of transportation to get there. I had my license for a month and got a backquote 91 Volvo that my grandmother used to drive as my first car. So that morning, I get to the building for my daily science class, and the first teacher who is helping direct traffic directs me to another lot. I go over to it, see one car in the other lane, and he motions me to go. I was turning right and was still learning as a newer driver that I had the right of way in that case. I start to turn in the lot, and there's another teacher helping direct traffic. She motions for me to stop, to which I put on the brakes, but before I can come to a complete stop, she walks out in front of my car, and I hit her. Not hard, but not exactly soft either. Aside from telling me to be careful, she also tells me that, for some reason, I'm not allowed to turn right into the lot. Adrenaline racing, I go and park my vehicle to go to class, and she comes and asks me for my name, to report to the principal, who also tells me to just be careful. No other disciplinary action point. Fast forward a few days later, and I get a call during my last class of the day at my regular school telling me to go to the principal's office, where there's a police officer there. I'm nervous as fuck, wondering what went wrong, and it turns out this lady who I hit began feeling some pains later on in the evening. Somewhat understandable, since a car is a heavy piece of machinery, and that I've been subpoenaed. My mother then comes in, and also seems a little worried. Keep in mind I'm only 17 at this point. I go to court 3 times. I give my testimony on what happened. She gives hers. Both of our attorneys make their cases. The judge later dismissed the case, saying that he gave me the benefit of the doubt for saying in my own words that I saw her motion for me to stop, believing my story. To be honest, I had about 3 possible charges from the DA facing me, including reckless driving, and the judge dismissed them. I'm thankful I told the story as clearly and as honestly as I could. You'd think after that I'd be done with her, right? Wrong. Turns out the first case was to try and get me charged with something. About 3 years after the initial case was dismissed, she wanted to take me to court again to try and file a lawsuit. I go through the process again over 3 long days. I was bored pretty much the entire time, wondering why I had to do this again. My attorney was awesome and pretty much felt the same way, going as far as to mock the plaintiff's attorney behind his back while he was making his case to the jury. Here's where the whole case blows up for the plaintiff. Until the last day of the trial, the plaintiff was unaware that there was security footage of the whole incident. I had been to court in 2010 and 2011, and only in 2014 was the plaintiff finally aware of the actual video evidence. My attorney showed it to the judge and the jury. The jury then deliberated for less than 10 minutes, declared me not responsible for damages, and I was free. What a feeling. I spent a total of about 5 days in court during this whole saga, and it was over just like that. TLDR, hit a teacher, get off scot-free thanks to 2 awesome attorneys, me telling the truth, and a security tape. Here's a story I heard from a retired judge. Years ago in Finland, a 17 teen had used a fake ID to get alcohol and was caught. She was a month or 2 away from being able to legally buy alcohol. This was at a time when Finland had no specific law against using fake IDs for situations like that, but it was obviously illegal, and the law that crimes like this fell under was falsifying government documents. For reasons unknown, rather than the police just taking the fake ID and telling the kid to grow up, they actually charged her with the crime, so she went to court. Her entire family was there watching as the 3 judges. Finnish system is very different from the one in USA. No jury appears, for example, were reading out the charges. Judge mentions that the minimum punishment for this crime is 1 year in jail and that it cannot be turned into fines. They pause to ask the girl if she had already found out if she can arrange to take the national school exams in prison, and that due to the severity of the charges they need an hour to decide on their ruling. Once the courtroom has been cleared of everyone, the judges go to a nearby restaurant to have lunch. When they come back, the judge starts reading the sentence and mentions that as there is no way to give a punishment lesser than 1 year in jail, they have chosen to instead disregard the charges entirely, which is a thing that they can do. Judges start packing their stuff, while everyone in the girl's family sits silently, not really understanding what happened. Finally, her grandmother walks up to the judge and asks what happened, and the judge just tells her that the girl isn't in trouble, but she better not do it again. Then the judge mentioned that these days a crime like that would be a €50 fine and nothing more, and that sometimes he had given out 2 to 3 punishments for disrespecting the court to the defendant, even before they have finished reading all the crimes they are suspected of, because some hooligans can't behave for 5 minutes. Not really a no-sheet moment, as those are usually when things don't go your way. Much more of a damn moment. Defendant is an insurance company who refused to pay for a clear and unambiguous fire loss that was not caused by my client. It was a wildfire that burned a couple dozen homes. My client's home was damaged, but not destroyed, but everything was in the home, and she was something of a pack rat. It was a home that would cost approximately $500,000 to repair, and she had $1 million in property insurance and $2 million in contents insurance, which was an extra rider. Much of my client's personal property was middle to high-end art and antiques, $1,000 to $10,000 per piece, which needed special cleaning quickly to preserve it. Smoke residue does all kinds of bad things. For about $300,000 in damaged antiques and art, insurance company is offering only $20,000 after the fire. The insurance company sent an adjuster out who did a really crappy estimate on the repair costs, but who refused to look at the contents. He said the desk adjuster handles the contents. About 18 months after the fire, we are deposing the adjuster who came out, and he admits that he was instructed by his manager to keep the costs down because we are getting killed on this fire. Pretty good, but not great. Most jurors can understand that kind of thought process. As a throwaway question, I ask him if he looked at any of the smoke damaged goods. Oh yeah, I really liked the original Picasso. It looked like an original. I offered client $20,000 if she was interested in selling it. Q. Why so much? I figured after putting the $10,000 in that was needed to clean it, I could sell it for at least $40,000 and make a profit of $10,000. Q. Really? Yes. And I also offered to buy the Chinese screen. I don't remember how much I offered, but I think it was $15,000. I figured after having it professionally cleaned it was worth at least $40,000, so I would have cleared another $10,000. Q. How much would you offer for them today? Have they been cleaned? Q. No pointer. The Picasso, maybe $5 grand. The screen? At most $7,500. Q. Why so little? Everyone knows if they aren't cleaned quickly from that kind of fire, then they are permanently damaged. Q. Did you tell anyone at insurance company about that? Oh yeah, I told inside adjuster that they needed to get on it and pay for professional cleaning because of all the antiques. Q. How did you tell them? It's in the claims notes, so I pulled out the claims notes that the company produced and show it to him. It's not their. Q. Why isn't that in the claims notes? I'm thinking he's mistaken. It happens. I don't know. He reaches into his briefcase. Q. Here's my copy of the claims notes. See, it's right here. 20 claims entries, roughly 4 full, single-spaced pages, had been removed. I believe it was done by the insurer. Almost all of these entries were where he was telling the inside adjuster how bad the smoke damage was and how much nice stuff was in the house and how it needed to be dealt with promptly. Opposing counsel called for a break and was on the phone with his client. We received a more than policy limits settlement offer by the end of the day and ultimately settled it for a much higher amount than that a few weeks later. My first and last trial as a young lawyer was on a legal aid certificate. I took on the case a week before trial, representing the wife in a divorce matter. The judge had ruled that there were to be no more adjournments or postponements. The only issue at trial was the quantum and duration of spousal support payable to the wife by the husband. 4 days before trial I received an offer to settle from the husband's lawyer, on the low side of reasonable. The wife rejected it outright. In my jurisdiction, if you reject an offer to settle before trial and end up going to trial and doing worse than the offer, the judge can order the loser to pay the winner's legal fees for the wasted time at trial. 3 days before trial I concluded that she was an alcoholic and incapable of properly instructing me. 2 days before trial I learned that I was the 10th lawyer on the case. She had either fired the others or they had quit. 1 day before trial I decided that I had no idea what I was doing and that I was better suited to be a real estate or corporate lawyer. On the day of trial my client showed up impaired by alcohol. Frankly, I could have used a belt of whiskey. I called her to the stand to testify and she was sworn in. Halfway through my first question she interrupted me, turned and looked at the judge. "Your Majesty," she said, "I would like to make a speech." "Oh shit." The judge looked at me. I shrugged my shoulders. The husband's lawyer slipped me a piece of paper. Notice of withdrawal of offer to settle. And the wife made her speech point after her speech. The judge looked over at me. "I have nothing more to offer, my lord," I said sheepishly. Point in the end, the judge ignored the husband's evidence and his lawyer's arguments. He ignored the wife's speech about the husband's infidelities. And he ignored my inability to offer anything useful to bolster my client's position. He did the right thing. He ordered support for the wife. The amount included living expenses, the cost of therapy for her addiction, and the cost of skills development and training that would eventually permit her to obtain employment and support herself. I switched over to transactional law. Obligatory, not a lawyer, but I was a reporter for a backwoods weekly in a small town, and being the young guy, I got all the boring sheet, town and county meetings for days. So, sitting in court, the trial I had been waiting for all week starts. A little oddball convenience store was being brought to task for selling pipes and bangs. This was in Van in the early 2000s, so the view on marijuana hadn't quite crested the hill and the backward bastards that ran the town had a healthy dose of moral superiority that trickled down through the various departments, except for the mayor. Dude was cool as fuck. So, the trial starts, and the prosecution rolls out about 30 bangs of various sizes evidence. They could have brought pictures, but the hotshot kid wanted to swing his dick around and show off the full collection. The trial goes on, the convenience store pushing the whole "their tobacco pipes" thing. The prosecutor picks up on this. "Well, judge," he says, "it seems to me we could call this paraphernalia anything we want." He pick up a bong, blows into it like a trumpet, making this weird reverberating fetched noise. Now, it's a musical instrument. Then he holds it behind his back, climbs up on his chair and jumps off. Now, it's a parachute. Most of the people in court start trying to contain a laugh, but poorly. I'm just sitting here, watching this guy play pretend with a bong in a court of law as part of his argument. He does baseball bat, umbrella, and the judge finally puts an end to it on which his broom after the guy started running around the room cackling. I was convinced I was watching a man go mad. The shitty part being I was actually watching a winning argument. I was a very young attorney, 4 years out, who got assigned to handle an arbitration after a software company used an arbitration clause to throw a case out of court about how the software failed to perform. Client didn't want to spend much money, so my big law firm gave it to me. Ended up on my own before a retired judge with 2 techs from the client as witnesses. Neither of them wanted to be there, and they were on travel per diem, so they only wanted to eat at McDonald's the whole time, so they could pocket their per diem. The software company had 5 attorneys at the other side of the table, including 2 partners. I'm presenting my case and doing direct examination of one of the techs, and he says something I know isn't true. I ask for a break and I'm like, "What are you doing?" And the tech says, "Well, I thought it would help our case." This was after I tried to introduce some documents, and opposing counsel challenged my foundation so I had to go into the bathroom and call a colleague to remind me what the element of the business records exception were. Opposing counsel had the same documents, some of Docsworth's, and they were just being dicks. So I go back in and ask the tech, is there something you would like to say? Tech admitted that he lied. Opposing counsel asked for a directed decision, that is, they win without having to present evidence, and the arbitrator agrees. Case over. I go home with my tail between my legs, and every partner is like, oh, you think that's bad? Let me tell you how I faked up my first case. So it's apparently a rite of passage and I didn't get fired. But the opposing law firm filed a Rule 11 ethics complaint against me personally, so I had to spend the holidays writing a brief on that. The arbitrator threw me a bone and rejected it out of hand since, as I said, they were dicks. A blonde and a lawyer are seated next to each other on a flight from Los Angeles to New York. The lawyer asks if she would like to play a fun game. The blonde, tired, just wants to take a nap, so she politely declines and rolls over to the window to catch a few winks. The lawyer persists and explains that the game is easy and a lot of fun. He says, I ask you a question, and if you don't know the answer, you pay me $5, and vice versa. Again, she declines and tries to get some sleep. The lawyer, now agitated, says, okay, if you don't know the answer, you pay me $5, and if I don't know the answer, I will pay you $500. This catches the blonde's attention, and, figuring there will be no end to this torment, agrees to the game. The lawyer asks the first question, what's the distance from the earth to the moon? The blonde doesn't say a word, reaches into her purse, pulls out a $5 bill, and hands it to the lawyer. Okay, says the lawyer, your turn. She asks, what goes up a hill with 3 legs, and comes down with 4 legs? The lawyer, puzzled, takes out his laptop computer and searches all his references. No answer. He taps into the airphone with his modem and searches the internet and the Library of Congress. No answer. Frustrated, he sends emails to all his friends and coworkers, but to no avail. After an hour, he wakes the blonde and hands her $500. The blonde thanks him and turns back to get some more sleep. The lawyer, who is more than a little miffed, stirs the blonde and asks, well, what's the answer? Without a word, the blonde reaches into her purse, hands the lawyer $5, and goes back to sleep. Not a lawyer, but I worked at the firm while this case went down. Straightforward personal injury case. 2 cars collided into each other. The accident circumstances are pretty simple, and the defendant definitely seems to be at fault. It should settle easily. Acting for our client, we try to settle the case, but the defendant refuses to admit liability. They say the claimant performed an unsafe maneuver, but they would have had no reason to have attempted such a maneuver. We say that's obviously not true. They say they have a witness, let's just call him Keezer Soze for the fun of it. They present a statement from Soze saying he saw the claimant attempt the maneuver. It's unsigned. Clearly they've just made this guy up. But without an admission of liability, the case has to continue. We take it to court. The court process lasts several months, exchanging evidence, agreeing upon experts and timetables etc., and claims usually settle as they approach the court date. Throughout this period we continually ask for more evidence regarding this Keezer Soze figure. The statement gets signed, but other than that the defendants fail to provide any evidence that this guy even exists, we offer them several chances to settle, stating each time that their whole case depends upon a guy who either does not exist or is not communicating with them. They refuse. We get to the court date. Outside court, Keezer Soze is nowhere to be found. He has failed to attend, and not only is the case destined to succeed as a result, but because it has been needlessly dragged on for so long, we will get extra costs awarded for having to deal with it. Catching, we offer the defendants a last chance to settle before court, so they can escape having to pay such a large amount. They refuse. In court, the hearing begins. There is a kerfuffle outside the courtroom. A man literally bursts through the courtroom doors. I am Keezer Soze. Oh. Shit. He approaches the judge. In his hands are a driver's license, passport, birth certificate and a utility bill dated within the last 3 months. He gives his evidence. Our case fails. Not a lawyer, but, out of the blue, I was summoned to court for a hit and run that had happened over 2 years prior. While there had indeed been an incident, I was able to prove to both the insurance company and the police that I could not have caused the accident. A guy who didn't see it happen claimed I hit his car. The dent was way lower than the part of my truck that didn't hit it, and the paint residue inside the dent did not match my truck. Also, I had 2 witnesses who witnessed nothing happening. To appease the guy, I gave him my details, but did not sign the accident form. He contacted the police and I waited around. He didn't for them to show up. They never showed, and I went to the station the next day to make a statement myself. I also contacted the insurance company myself to tell them they were about to receive a fraudulent claim involving me. I had pictures of everything that had happened. The police officer at that time told me I shouldn't expect anything to come out of this, and if it did, I had done everything in my power for it not to be considered a hit and run, regardless of whether or not the insurance decided I did cause the accident. So when I got the summons, I lawyered up. The firm I drove for doubled down on the lawyering and got their firm to work with mine. When I appeared in court, flanked by 2 lawyers, the judge asked me why I was so afraid. I explained that I was afraid that I was falsely accused. I presented my story, providing evidence and witness statements, and the judge could agree that I did everything right in order for it not to be considered a hit and run. He scolded the prosecution for not doing their job correctly and for harassing me unnecessarily. He asked my lawyers, who had primarily just spoken to conform to the law rituals, if they had anything to add. My lawyer, with the biggest sheet-eating grin ever, then added, "Your Honor, I would also like to add that my client's case has been past due by over a year." Judge's eyes almost bulge as he lays into the prosecution. I couldn't help but grin for a day or 2. The lawyer's bills kinda faded that smile though. I hosted a base jumping event at a giant popular antenna that was attended by people from all over the country. Attendance got out of hand and the party got pretty wild. On day 3 of the event I left for home, while everyone else was still jumping. Not 10 minutes after I left, a tower crew showed up and called the cops. In the ensuing chaos, as 15 people in 9 cars scattered, a car full of 5 of my closest friends was pulled over 20 minutes down the road, and the tower hand with the cop identified one of the people in the car as being at the antenna. As they were all Mirandized, one of them called me and put me on the phone with the deputy, who complained that none of them would confess to their presence at the antenna. After a discussion, he issued summonses. Though the charges might be obvious, I won't say what they were. I entered an appearance on behalf of all 5 of them and began filing motions to compel evidence, challenging the stop, etc. Obviously did not disclose that I was a witness to the alleged crimes or a co-conspirator. Thankfully, the felony charges the summonsing deputy wanted to file were not feasible, so it proceeded as an officer prosecuted case in a court of limited jurisdiction in a city where I'm not generally known in the bar, and one not of record. Cases are split between 2 judges in the court, and one of them dismisses those clients' cases outright at pre-trial. Other judge denies all of my motions, but I work out a favorable plea bargain with the prosecuting deputy that results in eventual dismissal for the remaining 3 clients. Side note, deputy says to me, "Did you know people come from around the world to jump off that thing?" To which all I could say was, "I can't believe there are that many crazy people out there, but I can tell you this case has sure put the fear of God in my clients." We go to put the agreement before the court, and the judge is filled with impotent rage at my clients who selfishly endanger others for a cheap thrill. His words: "Demands a longer term for the agreement and a full confession from each client." When I object, he advises the entire courtroom that if he doesn't receive a detailed allocution from each of the pleading defendants, that he will rip up the agreement, force them to stand trial, and find them guilty. Obviously he has seen no evidence and heard no testimony, and this is a serious unethical threat to deprive them of due process. So now I really wish there was a court reporter, because I'm ready to report this guy to the Judicial Ethics Board. But since there is not, and since my friends are funny morons, they each give a different patronizing version of what happened that makes this judge even angrier. Thankfully, the last of the 3 clients tells the truth that satisfies this judge, and our agreement is approved. Charges ultimately dismissed. And that's why the rules say never to take on representations like that. I'm a chemist and not a lawyer, but I had one of these moments. I'm sorry as this gets a bit technical, but I think it pays off. So I was asked to be an expert witness, and this was during deposition, rather than in the trial. But one of the things my client had been accused of was hiring an incompetent cleanup team. The case was a release of sulfuric acid, and they had brought in a vacuum trailer to hold the dirty sulfuric acid that they had collected from the ground. They then collected all of the sulfuric acid from the tank as well, to below where the hole was to stop the leak. What they couldn't collect with the vacuum truck they threw down sodium hydroxide on, and then powered absorbent and collected. The material that was absorbed could be transported off-site as a non-hazardous solid, but the waste sulfuric acid was a hazardous waste. They were alleging that the cleanup crew was incompetent because they hadn't neutralized the sulfuric acid in the tanker with sodium hydroxide, so it could be transported off-site as a non-hazardous waste. My moment was that no one, except me, understood how absurd that was. My initial response was something like, it isn't that they are incompetent, it is that my client isn't in the habit of hiring wizards, and they have to obey the laws of thermodynamics. This was in New Jersey and my attorney was a clone of Tony Soprano, look, diction, etc. He advised me not to speak to the opposing counsel in that way. I then had to explain to them that treating hazardous waste in a tanker would make it melt because of the amount of heat that would be generated by the chemical reaction. That the volume of the tanker wouldn't allow for neutralization, that it is illegal to treat hazardous waste along the side of that particular highway in New Jersey, as it is every highway in New Jersey, etc. I then had to explain what I considered high school chemistry to the opposing counsel, and judge point it was actually kind of disappointing, because they ended up settling, and I didn't get to go to trial. I'm not a lawyer, but I defended myself in a court case whereupon a woman wanted to sue my company claiming she was unaware of our policies. Plaintiff is late. We are talking at this point of the day. The only people left in the courtroom are myself, the judge, police officer and court clerk. Judge is about to grant me automatic winner and plaintiff comes full on running into the courtroom. Point she is dressed in yoga pants, flip-flops and a tank top. Has a full Starbucks refresher drink in one hand and a bag of Burger King in the other. Judge is incredulous at her manners and informs her she's late and he will not tolerate any further delays and let's get started. Point we go to the stands and he lets her plead her case. She does and then it's my turn. I hand out the evidence I had prepared and was well organized. Go through my prepared statement where I was rudely interrupted multiple times by plaintiff and the judge reminds her again to stop interrupting. Point she stands up and screams and says it is bullshit. That defendant is showing off with all this evidence and I object. Judge asks her if she has any evidence. She says I don't need any. The customer is always right. Judge shakes his head, states he's going to make his ruling, and states that I, the defendant, had won and complimented me on how organized and prepared I was. Plaintiff loses her damn mind, throws her drink down spilling it everywhere and tells the male judge that I clearly offered him some sort of sexual favors to win, and she is arrested and held in contempt of court. Point I had to get a transcript and recording of the hearing because people couldn't believe this really happened. Not a lawyer, but here's my oh shit moment in court. I was in court for misdemeanor marijuana possession. In most cases I would have just plead guilty and taken the punishment handed down. I was in fact guilty of possessing marijuana, mind you. Well, in this particular case my attorney advised me to plead not guilty and take it to trial because to the admission of the police officers that were present they entered my home illegally and my attorney was pretty confident they could get the case tossed out. Fast forward to my court date. I'm the last defendant to see the judge and every person before me either plead guilty or no contest. This judge was very strict and straightforward. So the police officers were called in. They recounted the series of events and why they chose to come around the back of my house and enter through a sliding glass door instead using the front door. The district attorney's closing argument was basically what is a cop to do? They knock, no one answers, they assumed someone could have been in danger, blah blah. So the judge looks at me and says loudly, what is a cop to do? Perhaps knock louder or leave when you are on a call for a noise complaint at 6 p.m. at night, and when you arrive there is no disturbance, and she dropped the charges. I for sure thought I was getting a guilty verdict and Since I didn't take a plea deal, they were seeking the maximum for that crime, which at the time was 3 to 6 months in jail and a year of probation. After spending 2 weeks in jail for some weed. This wasn't my experience, but was my father's story instead. He is a general civil litigation attorney in the Midwest. My father took on a client he hadn't previously met in person until the jury trial. He had obviously corresponded with his client, but his client was a Florida resident and my father's case was in Wisconsin. This was in the late 90s/early 2000s. My father's client was being sued for defrauding a businessman out of around $60,000. Essentially, the plaintiff was led to believe my father's client owned a bed-liner epoxy business and was looking for distributors. Each distributor would operate as an independent contractor and was required to maintain inventory, which they prepaid for. The plaintiff was convinced and invested heavily. My father's client sent approximately $500 worth of products which were not even his, just some generic, cheap epoxy he found. My father's client eventually totally ghosted the plaintiff, leaving high and dry with only a few $100s worth of inventory for a $60K investment. Anyway, my father's client had a criminal history, but my father filed a motion in limine to suppress this from the jury. The trial began, and the plaintiff testified about how he was swindled. As he is sitting there testifying, he makes eye contact with my dad's former client. My dad's client mouths the words, "I have your money." At that point, the plaintiff lost his shit, stood up, and yelled, "Did you see that? This guy is a goddamn crook. He rips people off all the time. He is a goddamn criminal." A mistrial was promptly declared. There is no doubt in my mind that my father's former client was a goddamn crook and genuinely just a really bad person overall. I Google searched his name a year or two ago and saw he was facing felony charges in Florida for calling in a fake homicide during a routine traffic stop to avoid paying the speeding ticket. At a friend's hearing for swearing in public and resisting arrest, friend's lawyer argued the swearing in public away as it was private property. Judge looked relieved, as was at end of the day most likely thinking, "Oh, an easy dismissal, and I'm off home." Police prosecutor was not having it, wanted resisting arrest to stand and it go to a court. I could see the judge looking like he wanted to die. A lot of legal jargon is being thrown around and the judge looks like he about to pass away when he stands up and yells at the police prosecutor, "Let me get this straight. You want to take a case to court over a man resisting arrest when he wasn't meant to be arrested in the first place, as he was arrested for swearing on his own property." The police prosecutor had an oh shit moment, dropped the remaining charge, and was gone by time my friend left. Another time was in for a minor thing waiting in court to plead a case away for charge no conviction. They used to charge all the weed cases in one foul swoop. Judge calls 25 people up, finds them all, done deal. Well, one guy was seriously ill, cancer by looks, and not winning. I was sitting, took him ages to walk to the dock. I could almost see the judge fall out of seat, find everyone else, then took a moment to ask the police prosecutor what the man was found with. A tinny, small amount of weed, think $20 bag. Judge asks, "Man, are you sick?" Judge gets cancer story, etc. The judge in front of everyone frothing at mouth asks lawyer if he should charge the man. Police prosecutor, "Yes, your honor, of course, judge. That's why you will never be a judge." Oh shit moment hits, and he backtracks, tries, "I understand, your honor, with the sickness." Judge tells police prosecutor if he ever sees same man in front of him again, he would have words with the police prosecutor another time for another more serious incident waiting to be heard. A quite pretty lady storms in the court. The police prosecutor this day was a lady as well, not bad looking, you could say very similar looking in fact. Top of her lungs, "You faked my husband, you cunt." My mouth comes open and I start looking around at who's she yelling at. Keeps walking and yelling same sort of stuff. It was the police prosecutor, haha. Hardest I've ever seen someone go. Judge called break and had lady detained to no doubt charge with some kind of disturbing peace or court, etc. Long story short, my case heads to a plea deal for and out of sheer luck or day or events I witnessed, get a charge without conviction. Thought I was getting a bracelet for sure. I was deposing my client's second criminal defense attorney in a lawsuit against his first criminal defense attorney who had withdrawn from the case due to having been elected to the bench in the same county, but not the same court, where my client's criminal case had been pending. After the lawsuit had been initiated, the attorney being sued contacted the second attorney, who my client had since fired, and asked the second attorney to turn over the client's file, which he did. In reviewing this discovery material, I found that the second attorney, months after having been fired, had submitted a sworn affidavit in my client's criminal case in order to obtain a subpoena for purposes of a civil suit. In this affidavit, the second attorney continued to represent himself as my client's defense counsel despite having been fired months prior. I developed the testimony of the attorney being deposed in which he admitted that he knew he was no longer my client's attorney after a specific day in November of the previous year when not only had he been fired, but was also ordered removed from my client's criminal case by the criminal court. I then called the deponent's attention to his sworn affidavit, filed with the court in May of the next year, in which he falsely represented himself as my client's attorney in order to obtain the subpoena. He admitted to this felony on video while under oath. When I asked him why he would file a false affidavit with the court knowing he had not been my client's attorney for more than 6 months, he pointed at the defendant in the lawsuit sitting across the table, the attorney who had been elected judge, and said, "Because he told me to do it." The lawsuit was soon after settled. Not a lawyer, but I have 2 stories. When I was 16, I plead not guilty to reckless driving and careless driving. I was leaving a convenience store down the street from my house during snow. The exit is kinda hilly, and my truck tires spun a bit, but I got moving. I drove past my house because I needed to turn around to park on the street. The cop comes flying at my claims I was trying to run from him since I passed my house. He wrote me a ticket for both, and if I remember correctly, reckless driving is a major violation. During the meeting in front of the city district judge, I explained my case without a lawyer. She told the officer, "You need to pick a charge because both are too similar to stack." I don't know if that's the case, but the judge has been known to be easy on first offense minors. My oh shit moment came when the officer started arguing with her about he wants both charges. Then they proceeded to both get into a yelling match as I just watched. I walked out that day with a $100 fine, no points and nothing on my record. Next story came much later in life during child custody case. My ex-wife current boyfriend knew he was going up to the stand and he showed up looking like a bum. My lawyer nudged me and said, "You see him, this is going to be fun." The oh shit moment was when the court stenographer and my lawyer were talking. After it was all said and done, I was within listening distance and the court stenographer said, "That guy didn't stand a chance once he walked in dressed like that." Being dressed poorly didn't help his credibility nor my lawyer twisting his own words on the stand and making him sound like a moron. I won that day. Two that come to mind were, in an armed with robbery trial, I was watching another ad prosecute. The defense attorney asked the lead detective if his guy took a polygraph. Detective said yes. Follow-up question, and my guy passed it. Isn't that right? Answer, no, he failed it. I frequently hear lawyers refer to the victim as the alleged victim. I find it irritating, but I understand the reasoning. But one time the defense attorney kept referring to his guy as the alleged defendant. Bonus. I was trying a Dewey case where the defense admitted to driving drunk but claimed duress because she was escaping from a violent assault she had just witnessed. She told a great story on direct, and my cross consisted of nothing but exaggerating to an absurd degree her duress story. I even offered her some tissues and water as I was going on. She played it up perfectly and fell for it hook, line, and sinker. On rebuttal, I recalled the arresting officer and introduced the paperwork where the person she said had just committed this horrible violent bloodshed signed the defendant out of the drunk tank 20 minutes after she got put in it. Q. Officer, did you see the defendant screaming for help when she got in the car with this other woman? A. Nope. She got right in the car outside the jail, no problem. Q. Officer, did you hear the defendant yell, "Help me, help me, I'm scared of this woman"? A. Nope. Was nice and pleasant. Had a guilty verdict a few minutes later. Edit spelling. Lawyer here. One case gave me an incredible double whammy. I had a client that had been under years of surveillance, but left the UK for the UAE without being caught for anything. Whilst out there he was arrested on trumped up charges with a confession tortured out of him. Meanwhile, the UK decides that this is a good opportunity to seize all his and his family's assets on the assumption that he got it by criminal activity. 7 years after being imprisoned, his charges are dismissed in the UAE and he comes back to the UK. He is a broken man, but suddenly the National Crime Agency have an unexpected fight. There is no evidence against him, but the burden was on him to prove he got his property legitimately. We had a real fighting chance. 3 days before we are due into court, we can't get in touch with him. He was arrested and imprisoned for unloading a van full of weed. Not a good start. We now have this trial with him in handcuffs flanked by guards. That itself was awesome, but it gets better. His mother spoke very poor English and was diabetic. She had to get up and simply present documents that confirmed her land was all inherited. She sat peacefully through the morning. She had an Urdu interpreter join her to give evidence. She is calmly sworn in. Our barrister asks her name and she explodes. She is ranting and raving. She shows the judge her wrists and asks her to cut them and kill her now. She will not calm down. All in Urdu, all to be translated uncomfortably. We guess she was slowly sinking into some kind of diabetic episode, but the judge makes her leave. We have 20 minutes break to try and calm her, but that is not happening. Game over. No chance of proving her land was hers and her son lost everything too. A lawyer now, but was doing juvenile litigation in law school. The state had 2 cases against my juvenile client. One, he was on a HD camera committing burglary, so the state had us dead to rights. The other case he was accused of involved him alongside numerous other adults, but no evidence other than the adult co-defendant's testimony. Now we were gonna plea on the first one and see if the state was willing to work with us on the second. Anyways, we have this power tripping prosecutor who just got sent to juvenile and hated it. He says no plea, we are going to trial on both. He starts yelling at us and says he is gonna have offer a deal to the adult to testify against our juvenile. He calls the jail without notifying the adult inmate's lawyer and has him sent down to pretty much incriminate himself. We run over to the PD's office and told them what's going on. Next thing we know, 2 public defenders are telling him no. He starts yelling at them. He then calls the adult inmate's attorney in full view of all the people in the gallery, offering a deal on speakerphone. Afterwards he says he doesn't need the inmate there and argues to us he had case law that violated confrontation clause. My law professor was losing her mind. The judge finally comes out and we know he's screwed. He swallows his pride and last minute wants to make a deal. We told him no, cause it came out he wasn't prepared at all. He ended up null prosequi the charges. The entire galley and numerous attorneys were in shock. Judge just was annoyed he dropped it last minute. It was a no sheet moment cause I always held all attorneys up to a higher standard. First case I tried in court was an auto accident. It had been running 2 years when my firm tagged me in. I represented the plaintiff's underinsured insurance carrier. They paid if no other insurance carrier was on the hook. Defendant's insurance carrier was denying coverage, claiming she'd cancelled the policy by mail the Saturday night before a Sunday morning crash. In reality, she thought she was following the insurance agent's instructions on how to merge her policy with her fiance's policy. My insurer has been decent, but was too cheap to depose the defendant's insurance agent who gave the confusing instructions and is now on the stand, so I don't know what the agent will say. I qualify the agent. He tells about his 20+ years as an agent, all the schooling and training he's had, etc. A key point is where the defendant understood that she was cancelling her policy. I ask agent, so are you telling me you think the defendant understood her insurance policy and what she was doing? Agent responded, no, nobody understands insurance. I don't understand insurance. My sheet moment was that this won that argument for the defendant and would put her insurance carrier on the hook. I could only mess it up from here. So I stopped, immediately turned to the judge and said no further questions. Defendant's insurance company tried to rehabilitate the agent. I responded and we went on. Defendant's insurance company was found to be on the hook. Not a lawyer, but I was a court officer. During jury selection for a felony, this kid walks into the jury box with a shirt that says "Rock her with the shocker" and had a hand logo making the gesture. Surprised to see this, I tap my partner on the shoulder, and I'm like, dude, number 6, that can't say what I think it says, right? To which he replies, yo, I think it does. So we are just thrilled by this development, because if you've ever sat through a jury selection process, it is boring as fuck, and this gave us something interesting. Sure enough, when it came time for challenges and number 6 comes up, the female ladder asks to strike the shocker for cause. Something to the effect of, that he would wear that shirt to jury selection proves he doesn't display the judgment for this case. Well, the male defense attorney has no faking clue what she's on about. They go back and forth a little on it, because he has no idea what she's talking about, and she is desperate not to explain it on the record. After a little bit, I tap the defense attorney on the shoulder, and I whisper to him, counsel, trust me, let her have this one. I promise I'll explain after. Well, he's a little surprised, since as a rule, we don't get involved in these things, but he consents to have the juror struck for cause. After we're adjourned for the day, as I'm hooking his guy back up, to take him back to corrections, he turns to me, and asks, so officer, what was that all about? So I lean over and very discreetly explain it to him. His eyes go wide, he looks at me, and he goes, oh shit. I'm gonna try that on my wife tonight. The next morning I passed him in the hall before we started. He looks me in the eye, winks and tells me she loved it. True story. Not joking. Not exaggerating. About 10 to 15 years ago I was in federal court in a rural district I'm not going to name. It was my first time in the district, and the first time in front of this judge. At the time I, male, had a long, blonde, ponytail, and my junior colleague, female, also had a blonde ponytail. We were there for a major hearing in a case worth north of $20 million. I'd never even seen the judge before. Anyway, it's just us. We represented the plaintiffs, court personnel, and probably 15 defense lawyers. All of a sudden the door to chambers bursts open, and this random dude in jeans and a polo shirt pops through the door, holds his arms in the air and hollers. Yes, it was a holler. I wanna see one lawyer for the plaintiffs, and one lawyer for the defendants, in chambers, right now. So, I nod at my colleague to stay put at the table and I walk over. The defense lawyer gets there first and walks through the door. The guy in jeans immediately steps into the doorway and blocks it. He gives me a serious look, theatrically slow, and does a full up and down gaze at me, twice. Then he reaches out and pulls a long blonde hair off of my suit coat, holds it up the air, and gives it a puzzled look. Then looks back at me, looks at my associate sitting at the table about 15 yards away, looks back at me, grins like a motherfucker, then leans over and whispers, just loud enough for me and the defense lawyer to hear him, well, counsel, how was she? I immediately lose it and crack up laughing. Defense lawyer loses it laughing. The guy in jeans sticks his hand out, deadpan, and says, I'm Judge so and so, glad to meet you. Come on back into chambers and we'll have a drink. And all, but I gave that moment a 1 in court point. I had to go to traffic court, and lo and behold, there's a prosecutor there, which I did not expect. She had a purple streak in her hair, so I'm guessing she was a new prosecutor to the DA's office, and they sent her to traffic to cut her teeth. But I don't know. There were about a dozen people there for cases, and about half a dozen lawyers. Before the judge arrived, every lawyer spoke to her privately. I had no lawyer. I was near last on the docket. Every case that came up with attorney representation was dismissed at prosecution's request. Everyone representing themselves was coming out guilty. Left, right, left, right. Another KO point. I noticed that she used the defendant's words against them every time. One kid rear-ended another car because my tires were bald. Well, that's illegal too, so here's your ticket. My turn. I get up and make my case, and she tries the phrase again. Only I had been very careful to admit to nothing illegal whatsoever. She said, by the defendant's own admission. Pause while she was trying to figure out what to say. I interrupted. By the prosecution's own lack of admission, the state can't even figure out what I did wrong. The judge was just a substitute, and he seemed fairly jolly for a judge. He chuckled and said, anything, Miss Lawyer. She came up with something lame, but it was clear she had no ammo point. The judge said the scales of justice are very evenly balanced in this case, but I feel that there is slightly more weight on the side of the defendant. Case dismissed. I looked at her. She just stared at me with jaw dropped, then slowly closed her mouth and recomposed herself for the next case. Priceless. Not a lawyer, but have testified as an expert witness numerous times. I'm a computer forensics guys. I hate testifying on cases that involve child pornography, but a local defense attorney asked me to, and told me that his client had a strong case. I accepted the job with the understanding that I would absolutely not lie in any way. I review the evidence and believe the defendant might not be guilty. Keep in mind, I only see a small subset of the evidence related to specific images and specific folders on a computer. On the day of the trial, for some reason, I ended up sitting through hours of expert testimony before I was called to the stand. At this point, based on the other testimony, I had not doubt the defendant was guilty. The defense attorney questions me, and I answer all of his technical questions. Then, the prosecutor questions me and asks me straight out, based on everything you reviewed and the expert testimony of the state forensics team, do you think the defendant downloaded child pornography? The defense attorney stood up and argued that I was not in a position to answer such a question. The prosecutor argued that I'm an expert and I heard the testimony of the state forensics team. Who would be more qualified? He said. The judge told me to answer without hesitation. I stated that I believed the defendant was guilty of every charge. The defense attorney let out a small moan. Then, the prosecutor asked me about 10 technical questions based on the additional evidence I saw during the state forensics testimony. In the end, the guy was found guilty and my testimony was one of the main reasons why. It makes me smile that the defendant has to pay $3,800 for me to help convict him. Wow, I actually have a story for this. Well too, but I like this one better, and I'm headed to work point, so I end up getting pulled over for speeding and not obeying an officer of the law. In Florida they'll stand in the median and try to wave you down. I didn't know this. I thought the lady was mad I wasn't slowing down so she could cross the street, so I may or may not have gave her the finger and kept on. I get to the next light and an officer on a bike pulls up next to me. Where you headed, bud? I'm going to work. How are you, sir? He says I need to pull over. Okay, no worries. He comes up to my car and gives me a heads up. Apparently the lady that tried to pull me over was faking pissed. He's like, I'm not giving you a ticket, but she is. Next thing I know, lady pulls up and is a ball of fire. Puts me up against my truck and patted me down. Asks what I have in my pockets. I said nothing, officer, you asked me to remove everything. She insisted I had something in my pocket and asked the other officer to double check. He said, what pocket? She replied, the front left pocket. I looked at him betrayed and gave him a look. He laughed and said, no, I'm not doing that. She cuffs me and goes to write my ticket infuriated. I'm talking to the male officer and he's like, what you got in your pocket, son? I said, sir, my pockets are empty, these are just tight jeans, and she grabbed my business. I wasn't aroused until she grabbed it the first time, and being in my early 20s it's all I needed. So I end up in court, since I was on probation, and had to try and fight the not obeying an officer charge, or whatever it was. The state attorney was reading over it, and was like, is this all correct? Apparently she patted me down. I told them what happened, and after some whispering with the judge they both gave me a look of surprise, and sent me on my way free of all charges. Also, I don't know how true it is, but I guess a lady officer can't pat down a male. Either way, I escaped the grip of Grady Judd. Not a lawyer, but my parents are. I used to go watch my mom in court as a kid. She was a prosecutor. One trial was a stalking case. I went with my mom to the scene before the trial with measuring tape to figure out how far the road was from the victim's house. Her ex-husband had been driving by and harassing her in violation of a restraining order. My mom was a real VIP in the courtroom. This guy didn't stand a chance. The defense attorney was really doing his best, but the defendant would not shut up during testimony. He was like an 80-year-old man, and he would talk shit while his ex-wife and other witnesses were testifying out loud in court. I could hear in the back. He needed a translator, someone to yell what the judge said in his ear, but he could somehow hear the testimony just fine. Anyhow, the judge gets fed up and tells the defense attorney to control his client and tells the defendant to shut his mouth. The translator had to yell the judge says to shut your mouth or something to that effect. I wanted to laugh, but it was caught. The defense attorney, who was an awesome guy, I just voted for him for judge actually haha, had to take him to a little room to calm him down after. The judge had to call a mistrial, but my mom got him the second time around, when I think he was no longer allowed to be present, because of his behavior. This was one of the weirdest things I saw when I was interning with a judge while I was in law school. This got long, so TLDR. Guy lies about having a PhD and really commits to the lie. Let's set the scene. Guy's car got impounded when he was arrested. I believe that he was arrested for having a substantial amount of marijuana in his car. Anyway, he was being charged with something or another, but the trial for that case was weeks away. Guy wanted to get his car from impound, but due to some mishap, the car had been destroyed. Guy claims he never received the notice that the car would be destroyed if he didn't collect it by X date, so he filed a separate case against the police to be reimbursed for the cost of the car and for his lost research. He claimed that his life's work was in the car. He also claimed that he was a medical doctor with a PhD and that the lost research meant missing out on a lot of money. This research involved using marijuana to treat some disease. Guy has decided to represent himself in this matter. Let's call him Mr. PhD. The judge I'm interning with allows me to sit in on a phone call between his clerk and Mr. PhD. This phone call was to get a summary of the issue so that we could be prepared for their upcoming court appearance. During this call Mr. PhD came off as odd, so much so that the judge decides to call the hospital he claimed to work for, located in our city and one of the top 10 hospitals in the US. He finds out that Mr. PhD does not work there, nor is he a real doctor, and shockingly, no PhD. But he is known at the hospital. Apparently he had a nasty habit of pretending to be a doctor there, going so far as to order lab coats with the hospital's name on them. The judge finds this despicable, decides that when Mr. PhD come to court he will ask him about his employment and will make it clear to him that there will consequences for lying. The day comes. The judge is in chambers along with his clerk and bailiff. I'm the only one in the courtroom, getting some work done on my computer. Mr. PhD shows up a few minutes early. Want to guess what he was wearing? His fancy hospital name lab coat. I go back to chambers to warn them. No one can believe it. Time for the meeting before the judge. Mr. PhD argues why he needs this research, how he wasn't properly notified, etc. Judge asks him about his education. Mr. PhD assures him that his qualifications are real. Judge tells him that he spoke to the hospital and knows he doesn't work there. Mr. PhD admits that he doesn't actually work there, but says that he has collaborated with other doctors there for his research. He maintains that he is a medical doctor with a PhD. The judge warns him about lying to the court, but Mr. PhD is adamant. So the judge asks if he can provide evidence of his qualifications. Mr. PhD says no problem, and that he can bring it to us that day. Mr. PhD leaves and none of us believe that he's really going to come back. The judge returns to his chambers and I continue my work in the courtroom. No more than 10 minutes go by and Mr. PhD is back. He had brought with him a diploma frame box. He comes up to my desk, opens the box and quickly shows me his diploma frame. He closes the box and gives it to me. I tell him that I'll go show the judge, but before I'm even out of my chair Mr. PhD says he'll come back for it later and leaves. Weird, but okay. Before going to chambers, I take a look in the box. Now this was a very nice diploma frame. Very expensive. I know this because it came from my campus bookstore and was the most expensive frame that they sell. I unwrap the frame and take a good look at it. It wasn't a PhD. It was, in fact, a certificate of completion for a one-day biology seminar. I couldn't believe it. The judge couldn't believe it. Mr. PhD never came back for it. He was ordered to surrender any and all apparel with hospital's name on it. From a reverse angle, I was caught speeding around 30 on the highway, early 20s era of my life, and also driving on a suspended license that I didn't know was suspended from some really dumbass administration thing at the DMV. Point I got into court wearing my best suit and politely approached the prosecuting attorney for the state, and he looked at me and said, "Last name?" And I gave it to him and he said, "Okay, if you plead guilty to the suspended license, I'll make no recommendation to the judge and I'll null pros the speeding infraction." I took the agreement and the judge said, "Son, this is a class A misdemeanor you are pleading guilty to and that can land you 6 months in jail. You do realize the seriousness of this, correct? You have no legal representation, yada yada." I was very respectful and threw in "Your Honor" a lot and said that I had no prior criminal record and explained the suspended license and said something like, "I felt pleading guilty with explanation would be best, Your Honor. I don't wish to waste the court's time on a very stupid mistake on my part." The judge seemed to love it and gave me PBJ, 6 months staying out of trouble. Every time I've been before a judge, just dressing nicely and being respectful has always paid off. Every time I have to sit in court and watch people before me, I'm always amazed how some people dress and address the judge. No man, I didn't do no faking 90 in a 35. That cop is lying. Like, don't call the judge man and definitely don't cuss in court. It blows my mind how disrespectful some people are towards a man that is basically your god in that room. I was the judge's clerk, attending a wrongful death case. The procedural posture of this case was horribly twisted, but in a legally relevant way. In short, the plaintiff committed suicide, and his estate, widow, brought the wrongful death case against those who allegedly drove him to suicide by patrial motion. However, the case was split into 2 trials, the first trial involving a different matter. In this first trial, the fact that the plaintiff committed suicide was determined to be so distracting and possibly unfairly prejudicial that it was to be excluded from evidence. Both parties had to deftly talk around the fact that the plaintiff's wife, and not the plaintiff himself, was the only one present in court. No lawyer was allowed to ask a question of a witness in open court that might solicit as an answer the fact that the plaintiff committed suicide. Well, about 3 days into the trial, the widow's brother was on the stand, and someone asked him something about the plaintiff's mood. The brother said something like, he was fine until he killed himself. He said it so nonchalantly that you could miss it if you weren't paying attention. But it was clearly verbatim testimony and arguably grounds for a mistrial. I tried not to react with a gasp. I just lifted my head very slowly from my work, turned very slowly to get a look at the juror's reaction. No reaction. It was so unexpected in the context of the trial thus far that I think it simply didn't register in the juror's ears. Neither attorney brought a motion for mistrial. They just quickly continued on, as if it didn't happen. I was defending a very close personal friend in municipal court for a minor moving violation. He was driving his brother's car at the time and the PO wrote the ticket out to the brother, car owner, not the actual driver. During discovery I requested the dash cam footage and you can hear the PO clearly say, "Have a nice day and drive safer out there." Driver's name. I'm thinking, sweet. Even the PO acknowledges that the ticket was intended for my client, not the vehicle owner for whom the ticket was written, so this should be a piece of cake dismissal. Prior to the hearing I talked to the prosecutor who apparently forgot himself that day. He asks me to step into an office, which is unusual for municipal court pleas, and proceeds to lose his sheet. He starts accusing my client of providing false identification to the officer. Felony, big deal. Oh, your faked kinda accusation, driving without a license, resisting arrest, you name it. He then goes on to say how those people do this all the time, and that he wasn't going to stand for it, etc. To give a little context, those people refers to Koreans. My client/friend is a Korean, but he's born and raised in New York City. Never even been to the motherland. The town I was appearing in has a very large Korean population. I almost lost myself for a minute given my familiarity with the prosecutor and venue, and my rage over him simply making a statement about those people, whom I have grown fond of as awesome neighbors. Frankly, I sat there quietly for a moment so as to not stoop to his level and lose my composure and simply asked, "Are you done?" He just looked at me puzzled. Gave me kind of that confused dog head tilt motion. I reached into my briefcase and provided him with a CD containing the dash cam video. I asked him if he'd like a minute to review the footage before we continue, to which he cavalierly responded that he was ready to try the case right there if need be. I pushed the CD forward and told him, look, prosecutor, from one colleague to another, I implore you to watch that video one last time. My client didn't do anything like what you've described, and it's very clear. I would feel very bad if the judge is forced to tell you how wrong you are, when you could simply take my word for it now. He gave in and watched it. After about 90 seconds he comes out of the office and walks right up to me. He dismissed the ticket and profusely apologized. He stated that he mixed the case up with another, to which I gave him the universal really, bro, look, we took our W and left it, but I lost a lot of respect for that prosecutor. My buddy now thinks I'm Perry Mason, which is just fine by me. I'm no lawyer, but this one still makes my dad's friend laugh, and one of his favorite stories to SharePoint. So my dad's friend was a sheriff for the local county. I was in the military deployed overseas. While I was gone, I guess I got a jury notice at my dad's place. I don't show. Warrant is placed for my arrest. Sheriff calls my dad and goes, hey, you do know your son has a warrant out for his arrest, right? My dad freaks. Sheriff goes, let me look into it. He finds out why I have the warrant. Sheriff goes to the adder in charge of cases like this. Dude is a giant asshole and requests my warrant is dropped due to me being overseas. Adder pretty much tells him to fuck off and that I had better show up to court on the date he wants. So Sheriff and my dad reach out to my command. Command gets a hold of me. I call and find out what's going on. Sheriff has a plan to make the adder look like a moron in front of the judge, who I know due to playing little league football with his son. So my court date comes. Judge calls my name. My dad approaches and asks permission to be there in my stead. Judge looks at my dad but goes okay. My dad explains how I couldn't be there or avoid jury duty on purpose due to being deployed to Afghanistan. Judge is smirking. Adder is demanding proof. So in comes the sheriff with a laptop attached to a TV. I had Skyped and talked to the judge. Just as the judge is about to drop my warrant, Adder pipes up, how do we know he even is overseas in a war zone? Funnily enough, right around then some Taliban guys decided to try, and more to the base I was on. You hear the siren, the call to take cover. Of course I had to go, but according to my dad, the adder sits down and barely mumbles, please drop the warrant. Not a lawyer, but a witness for the defendant. This was back in 1988 and defendant sold a computer system to a doctor for their practice to bill patients. I was hired through the defendant to custom write the billing system since I had written their own alarm monitoring system earlier. So I get with the doctor's office manager of 10 years, design and code the system to her specs. We put the system through acceptance testing and everything works on the advertised point until office manager is fired a year later. I offer to conduct an interview with their chosen replacement to see if she knows how to work on computers. Back then, not everyone did. They turn my offer down and hire her anyway. Suddenly, my system is losing balances and more. The new manager claims she's doing everything right and the doctor is concerned. I offer to sit and help the new office manager throughout an entire day to see what I can find out. While watching her enter a $150 charge, she enters L50.00 lowercase l and I catch it. This is the way I entered numbers on the last computer I used. Yeah, sure. On a manual typewriter, I said, since they saved a key by not having a numeric 1 key and used a lowercase l instead. And that caused the $150 to become $0, written in complied basic using the val function. And after this case I wrote filters just to catch this problem. Anyways, I tell the doctor that she has no computer experience and they should fire her. Instead, he brings in another consultant without my knowledge, who mucks with the path statement in the autoexec.bat file, and now my code can't locate the retrieve database and everything goes to pieces. End result, the doctor sues the seller of the PC in court in Memphis. We finally get the trial going, and I'm a witness for defense. I wait my time in the hallways waiting to be called. After a number of hours, I'm called into the courtroom. After being sworn in, the doctor's lawyer approaches me on the stand and introduces himself as Howard attorney. You might not remember me, but we shared many classes in high school together. Well now, suddenly you ain't Mr. Doctor's lawyer, you're little Howard attorney from high school who sat in front of me all junior year. He instantly wiped away any advantage he had being plaintiff's attorney. Howard goes into questioning me about how the statements were designed, how hard they are to follow. Then he asks me a hypothetical question about someone coming in for an appointment in August, but not paying the $50 charge. They would owe $50, right? Yes, and if they do the same in September they'd owe $100, right? Yes. And again in October, they'd owe $150, right? I'm starting to sweat a little, because maybe he has one of those $L50.00 statements from the new office manager. Howard walks up to me, hands me the statement, and asks how much does this statement say owe, playing it to the judge. I look it over, and start to smile. I said I don't know about you Howard, but I always pay the balance the statement says I owe. In this case $150. He grabs the statement from me and says where? And I pointed out him that the statement has a balance of $150 owed. He just walks back to his chair, slowly shaking his head. At this point, the judge starts asking me questions about the problems the system had not finding the data. I tell him that the consultant the doctor hired had made changes, so my program couldn't find its data. Because of the way I answered him, he asks did they make changes to the path statement in the AutoExec.bat file. Yes. The judge is a fellow programmer. Suddenly he and I are going back and forth discussing the system in technical terms, while Howard attorney tries to get a word in edgewise. Even the court recorder had to ask how to spell subroutine. It was absolutely glorious. In the end, the judge ruled 100% for the defendant. He ruled that the system had been designed to match the system used by the good doctor's office for years. And even though the statement design could be confusing, it's what their original office manager used. She had been on for 10 years and testified for us. In the end, he said that the lawsuit should never have been filed. If only little Howard attorney had not clued me in on who he was, he might have been able to intimidate me on the stand and maybe the judge wouldn't have asked me questions. I actually had fun that day. I've seen defendants show up drunk to court a couple of times. That's always amusing. Here's a story, but it's a bit long, so bear with me. I represented a guy named Rocky out in small town America. Rocky was about 5 days away from discharging his felony drug probation, 5 years suspended sentence, when he got drunk and crashed his car. Ironically, he was out celebrating his impending discharge from probation. Rocky was on probation because his buddy the drug dealer had 2 strikes, and when they got caught with drugs in the friend's car, Rocky took the charge for his friend. Well, Rocky's truck exploded during the car wreck and Rocky was ejected from the windshield, breaking his neck, but not severing his spine, upon impact. In the smoldering remains of his truck, police find a hunting rifle, which also makes Rocky a felon in possession of a firearm. So now Rocky has a probation violation, a new DUI charge, and he's a felon with a gun. Not good for Rocky, right? Well, if Rocky was anything, he was an honest guy. He threw himself on his sword and owned up to what he did. His probation officer actually liked him a lot and cut him another sweet deal that the county attorney went along with. Rocky would go to violators camp, which is in a penitentiary, but kept away from general population and is pretty much minimum security. His time at violators camp would be just enough to get his JED, basically a few months. A sweet deal when he's looking at about a decade otherwise. Rocky takes the plea and we send him off to violators camp. The next day, I get a call from the judge's office to come back down to the small town for Rocky's sentencing. I said that there must be some mistake. I'm told that there was no mistake and that it'd be easier if I just started driving back down to the courthouse. Well, I get there and Rocky, complete with halo from the broken neck, is sitting at the defendant's table. I go back to chambers to talk to judge and prosecutor about what the heck is going on. Turns out Rocky was a bit nervous about going to prison for the first time, so he smuggled, you can figure out where he hid it, pot, rolling papers, matches and a striking stone into the facility. His first night he's smoking up and because it's pot, the entire cell block smells it. Well, the guards send the dogs in to chew him up a bit, because that's their sop. When an inmate has an unknown substance, we go back to court, and the judge states, quite smugly, that the earlier plea deal is up in smoke, and that he's now going to impose full sentence, as well as additional prosecution for the smuggling charge. So in the space of 2 weeks, Rocky managed to turn 5 days of probation into about 20 years in prison. Background: not a lawyer. Ex left me a single dad when son was 2 years. Sued me for custody when he was 10. 10 years ago now, I found myself in a family court mediation which was akin to the Twilight Zone, although this ended up working in my favor. The thing that astounded me the most was that out of the 3 lawyers in the room, not one of them had thought to bring a copy of the existing parenting order. Not only had I brought a copy with me, but I had studied it quite a lot the night before, and found a loophole due to some inconsistent wording by a previous judge. As it happened, my would-be lawyer at that time never came to any of the mediations, but sent along a junior who was very attractive. Unfortunately, sitting there looking stunning opposite the ex was her only real contribution to the proceedings, although some might argue that that in itself was worth every penny of the lawyer's bill. Retrospectively, I'm pleased I didn't tell her what I had planned, so she could talk me out of it. Essentially, I had previously been strong-armed into contributing financially to the odd week the ex would have our child during school breaks. Bear in mind that normally she paid me child support as I had him the bulk of the time, and I was not legally obliged to pay her a cent under normal taxation laws. Despite attempting to keep my integrity and pay it as I had agreed, would have done so without it being included in the parenting order, she continually held it over my head that I owed her money and would complain that I hadn't paid enough, etc. Which really tells you what the court action had all been about. I patiently waited for my opportune moment to bring this point up, but it never came. It was like the other lawyers could smell that I had something cooking and were keeping things moving, so I couldn't get a word in. Or perhaps this is just how they operate, I don't know. Finally, the lawyer who was chairing things said, well, if that's everything, we'll wrap things up. I started to protest, but he stood up out of his chair and carried on as if I hadn't said anything. So I mustered all my gumption, well, voice projection, and said, hey, I'm not finished. Sit down. To my surprise, he did as he was told. I then pointed out to everyone in the room that the bit about me contributing financially in the school breaks had been slotted in under the Christmas vacation heading. Therefore, I was only obliged to pay at Christmas and not any other time of the year. I further iterated that I wanted this clause removed from the order, not so I didn't have to pay, but so that it couldn't be used to beat me around the head. If it was not removed, I would only pay at Christmas. My stunner of a junior lawyer looked a tad panic-stricken, as if I had just torpedoed everything, which essentially, I had. The other lawyers looked at me with annoyance, presumably because I had just taken control of the meeting and set my own agenda. This was clearly not something they were used to, and nor was I for that matter. But I liked it. The meeting never really recovered. Now that I was drunk with power, they all knew this was going to be the point that had to be resolved. I successfully negotiated the removal of that clause. I was accused by the ex of bullying her into a corner. Well, actually, that was the guy you had backed into the corner fighting his way out. I was being painted as the aggressor when coming back off the ropes, which was fairly familiar to me. Certainly being politically correct had not previously brought me any justice, but I had wrestled it from them like a crazy shopper on Black Friday. Subsequent to this, I did in fact continue to contribute financially as I had agreed, until such time as the ex decided she could feel free to ignore certain significant parts of the order herself, at which time I promptly stopped paying. She never understood why I stopped, but by that time I was long past caring to explain myself. TLDR, it pays to read the parenting order before court, for loopholes. I was on jury duty, which lasted only 3 days for this particular case, and there was these really dumb women as a defendant who was accused of forgery of a couple of credit cards and trying to buy a £1,500 handbag from a world famous department store. She claimed she was given these cards by random strangers who were kind to her and just told her to spend it on whatever she likes. Since she's beautiful and everyone just gives her stuff, she takes it, and apparently, in Chinese culture, they don't ask for strangers' names when talking to them. So she didn't ask their name and just took stuff of these random people and has no way to communicate back to them. Even her translator is like, what the fuck? There was a bunch of other dumb stuff too which made her sound like a dumb blonde bimbo. Then they showed us the credit cards as evidence, which was a fake bank called RBC. I clearly remember it didn't have the long card or sort code number at all. The other lawyer first mentioned as Bank of Scotland until one of the juries pointed out the mistake. Then she claimed it was Canada then China till the judge pointed out that there is no Royal Bank in China. Lawyer just gets embarrassed and sat down. Then the defendant's lawyer makes his closing speech. His client is dumb and stupid, but you don't send people like that to jail. We found her not guilty within 2 minutes of being sent in the room to discuss a verdict. The judge let her go, but told her to stay away from strangers. Like what you tell a small child. Not a no sheet moment, but pretty dumb and exhausting case, and also lack of preparation by the other lawyer. Not a lawyer, but was a defendant wrongfully charged. My roommate outran about 10 cops and managed to ditch them before hiding in the bushes. Nevertheless, they managed to find the vehicle and towed it. He got home later and called the cops and reported the car stolen. Everyone knew he was the driver, but they couldn't prove anything. The cop interviewed him for an hour or so. The same cop who initiated the chase, I guess. Anyway, they started cruising by our apartment at different hours of the day and night, sheriffs, and shining their light into our windows. Low-level harassment stuff. One morning, just as I was about to begin a new job that day, I go to leave, and my truck has a flat tire. So I pull it off and begin changing the tire when two sheriffs roll up in separate cars and get out and start questioning me about this incident. They pull out a Polaroid Instamatic camera before the internet and JPGS and take my mugshot and tell me they are going to charge me with this sheet. They also tried barging into my apartment and I told them they needed a warrant. I dear bung out and sheet and didn't want them in there anyway. A few weeks later, I was partying in a public place where I shouldn't have been, was only 22 and still dumb enough to do things like that, and got nabbed, went to court, got harangued, found out I was being charged with these things that could put me in jail for a year or two, and freaked the fuck out. Came home, told my roommate and friend that I really didn't want to rat on him, but was not comfortable with the idea of a faking public defender as they are not going to even try. Turns out his girlfriend had money coming from a personal injury lawsuit. Her mouthpiece, lawyer, was something of a minor celebrity. He had represented some prominent figures in the sports and entertainment fields as well as a local born king accused of murdering a family member. He met me, and the first thing he said was "fuck those pigs," so I knew I was in the right place. Anyway, we come to trial and the cop on the stand swears up and down that he could make a positive ID on me as the driver whom he saw for all of 3 seconds as he tried to cut off the vehicle and it sped around him. Meanwhile, I sat there wondering what the hell was going to happen, and then my lawyer brings in my roommate who had gotten a haircut. We were both metalheads and had long hair, and asked this guy on the stand if he recognized this person. The cop says no and basically says something to the equivalent that all long hairs look the same anyway. My lawyer dismisses my roommate, and then the court, which was pretty much a closed session, no real witnesses, except my pops who was there as moral support for me, freaked out. They called my roommate back in, and he was put on the stand. They asked him under oath if he drove the car that night, and when he took the Fifth Amendment there was a big commotion. Haha. They had to send for another lawyer on the spot to represent this guy. Previously my lawyer had advised me for a bench trial as jurors are faking idiots who'll always believe a cop if given a chance. The judge pretty much called an end to this fiasco as it was clear that the cops had faked up this case and were just looking to pin it on anyone, or maybe they hoped to pressurize me to fold and rat.tl/dr. Nearly went to jail for something I didn't do. KG lawyer pulls Perry Mason stunt in courtroom, amazes courtroom, and I walked. Probably not the oh shit moment that op was expecting, but this past summer I was sitting in a federal courtroom in the same courthouse where a Mr. Paul J. Manafort was being tried, but we were on a different floor, in front of a different judge. My boss was doing an arraignment hearing for some dudes that had been transporting weed across state lines. The area I was working in was not particularly kind to criminal defendants. Read as extremely high conviction rates and didn't look too kindly on drug offenses. Read as mean judges, mean marshals. There was already a considerably high amount of security given the VIP defendant downstairs and Juzo Asani / other members of the special counsel's office who were trying the case. The marshals were mean mugging our clients pretty hard, not outside the norm for this jurisdiction. Suddenly, in the middle of my boss addressing the court, two of the marshals grab their earpieces, jump to their feet, start screaming at the defendants to stand up, and drag them away into lockup, all while some other marshals grab the judge and escort him out of the courtroom and into his chambers. 3 agents came running into the courtroom and 2 of them had their guns drawn. They also ran back into lockup, and one of them demanded that we vacate the courtroom immediately. Everyone was, as you would expect, absolutely terrified. Marshals, especially those serving in the federal courts, usually handle their business with no fuss and are cool under pressure 24/7. Seeing them react in such a way scared the shit out of everyone. There was some loud noise from down the hall and someone said something about an active shooter, which only whipped the members of the public, including about 15 to 20 family members of the defendants, who were watching the case, into a frenzy. Turns out that 2 prisoners got into a fight in lockup, and another guy had a seizure and needed immediate medical attention. For about 5 to 10 minutes it was pretty scary. Then they called us back in, refused to release our clients on bail, and called it a day. Not a lawyer, but have had a slight one while in court for a speeding ticket. The prosecutor talked to me prior to going before the judge and asked if I planned to plead guilty. I wasn't really sure what else I could do, since I had no evidence that I hadn't been speeding. I had been, and flat out told her it's a judge. I'm a citizen being accused of something by a cop. Do you honestly think he's going to give half a shit what I say? She kind of recoiled, got a very nasty look, and told me there was no need for that kind of language. I just kind of shrugged, and she accepted it, let me go on back out, and went on to find the next person she had a case against. My last name is in the back half of the alphabet, so I sat there just watching each case get called, and the judge go through them. It got down to about a couple of handfuls of people left in the room and I start looking around and realize something. I don't see the officer anywhere. She passed by around this time and I motioned to her, and she stopped by. I told her, you know, I changed my mind. Even if they don't listen, it just wouldn't be right for me to lie and say I did it when I didn't. She stuttered through a no, okay, and stepped out into the hall. Came back in a moment later, and after 2 more cases, they finally called me up. The judge asked for my plea, and I plead not guilty. He turned to the prosecutor, who starts going on about how she just called the officer a few minutes ago and didn't get an answer, but he had been here not that long ago, and the judge shakes his head, tells her he's noticed me sitting in the back patiently this whole time. It had been about an hour, and that he wasn't going to make me wait any longer. He asked me what kind of car I was driving at the time of the incident and I answered. He gave me an odd look and said that's not a fast car. To which I replied no, it really isn't, and he dismissed it, told me to have a good day. DL. Doctor, walked into court expecting to have to pay speeding ticket plus court costs, and a no-sheet realization helped me weasel out of it. Not a lawyer. Small rural town, civil court. In the US. I was 7 or 8 at the time, and don't remember all of the details. So, when I was a kid, we had a German Shepherd. Beautiful purebred dog. Also liked to bark. Got her a bark collar and the smart girl figured out the arm and disarm timing, so she could bark in bursts without getting shocked. So yes, she was a loud girl during the day. We were sensible enough owners not to have her out late except to poop, and took her back inside before she had a chance to get going. Anyhow, like jerk neighbors are prone to do, our neighbors 2 doors over decided to take us to court for a few hundred for the noise problem, or what have you related to that, at great exaggeration. Never mind that their lab barked at and ran to anyone who passed by the front at any time of the day. So we go to the little town court next to the library, and our neighbors were there. Prior to the day, my mother had gone around the neighborhood with a Google map printout and noted every house whose dog was out and barking. Basically 2/3 of the neighborhood, like I said. Rural town. Turns out that she didn't need it. Judge also happened to live in the neighborhood, took walks frequently, and knew the plaintiffs by their dog. His official take was something like, "We all know dogs bark, live with it, fined my mother $5 in front of them." Basically a slap in their faces. She walked up and paid right there. Neighbors left with heads hung low. Now, California was serving as the lone alternate on a jury for a domestic assault case. The defense was trying to get a piece of evidence entered into the record that was an alleged video recording of the plaintiff, the victim, returning to the house of the accused and trying to get back with him a year or so later after the assault happened. Because it didn't pertain to the truth of the actual assault, the judge ruled that the evidence and all testimony regarding the evidence be stricken from the record. The rest of the jury went in for deliberations, and because I was interested in hearing the verdict, I waited in the antechamber outside the courtroom while they came to a verdict. The defendant approached me without his lawyer and sat across from me while I tried to ignore him. A few minutes passed, and he pulled out his phone and started playing some disturbing audio of a very flustered and emotional woman's voice. It takes me a bit before I realize, oh shit, he's playing the faking video. I immediately get the bailiff's attention and tell the judge what happened. He tells counsel and myself that it's a good thing that out of all the jurors it happened to me, since the incident thankfully would not have an effect on the verdict. But I don't know whether or not something like that would be grounds for some kind of contempt charges. In any case, I didn't stay around longer to find out. The case ended with the same verdict I would have ruled for it. I was in traffic court for a moving violation waiting my turn in front of the judge. He spent about 45 seconds on each case before slamming the gavel. Next, I'm not a lawyer. Fourth one up to the podium was charged with making an illegal U-turn in front of a cop car with its lights and sirens on. The cop car T-boned her vehicle. She began arguing with the judge. The judge kept trying to ask her if she wanted to plead not guilty, and she kept ignoring his question and trying to correct the record. People in the room started to giggle, which annoyed the judge. It was obvious he didn't want to find her in contempt and eventually entered a not guilty plea for her and got her a trial date. She exited still railing about how the cops were trying to set her up. I didn't hear no siren. Fifth one in front of the judge brought a banker's box of documents up to the podium. If I remember correctly, the charge was parking in a loading zone. She pleaded not guilty and explained what happened and started describing the evidence she brought to prove her case. The judge cut her off and told her he was finding in her favor and dismissing the case. She began arguing with the judge because she wanted the opportunity to lay out all this evidence and the injustice she had suffered. She only stopped talking when the judge reminded her he had ruled in her favor and asked her if she wanted him to reconsider that point. I was next. I plead guilty and got a $75 fine. Next, on the way out I bumped into both women. The first one was at the payment window arguing with the clerk. When I came up, she was disputing some other tickets and suddenly walked away while the clerk was in mid-sentence. The second one I met while waiting at the bus stop. I was curious, so I asked about her evidence. She must have spent 30 hours at least gathering and organizing all of it. She was still frustrated she hadn't had a chance to prove her case and acted disappointed there would be no trial. I had a post-conviction evidentiary hearing. Oh boy, the case was pretty sketchy from the beginning. Newly discovered evidence. The client shows up with 3 affidavits from trial witnesses who said that the cops leaned on them and made them testify. In the response to the motion, the state's attorney argued that because the witnesses could possibly face perjury charges, the court should appoint an attorney for them. When we found out that the hearing was granted, we hired her own attorney to talk to them. One of the witnesses had already pulled out by this time because she wanted a payoff. Another witness backed out after consulting with the attorney. So, we were left with the least important witness, who never really strongly identified my client, just said that she had assumed it was him, based on the circumstances. In other words, she was the one who really had nothing to recant. We also had a friend of my client's, a guy who was called, only to establish the timeline of when my client would have learned that the witnesses had recanted. We needed to show that he had only discovered the recantation recently, and this guy was going to testify that somebody else had told him that the witnesses had recanted, and he then told my client on a certain date what he had heard. I was concerned when I saw the guy because he looked super thugged out and called in straight from the corner. Bright red tracksuit, facial tats, chains, hungover red-eyed, prison physique. Just a nightmare. He bailed at the beginning of the hearing. When I tried to call him, we couldn't find him, and the judge gave us a minute to look for him, and I had to come back and say that he had left the building. Then I had to examine the one witness we did have, who actually said that she spontaneously decided to write the affidavit and personally file it in court. Of course, it was actually me who had filed it as an attachment to the motion, along with the other 2 affidavits, all notarized on the same date. She didn't know anything about the other 2 affidavits. I don't do any trial work and I only have evidentiary hearings every year or 2, so this was my OS moment. Not an attorney but social worker. We work specifically with folks with developmental disabilities, so we get involved in a lot of guardianship issues. A caseworker I supervise was having an issue with an individual we served that had the local public administrator as guardian. The individual wanted to move in with a family member who was now able to be her guardian and lived in a different town/county. The PA, who already have way more wards than they can handle, readily agree that if the family member cares enough to hire their own attorney, that they wouldn't contest guardianship. If there were no red flags, there are several checks in place to ensure potential guardian would be a sufficient guardian. The family lives in a small town, so the caseworker tracks down a couple of people who practice in the area and gives family the info. Family follows up and gets an attorney that claims he'll have everything submitted and wrapped up in a month. Not an unreal suggestion. Months go by and this guy has done nothing. Family continues to call and he just gives them some BS and says it's in process. Still nothing. Family finally gets frustrated and lets social worker know, who checks with me on how they proceed, as they called the attorney and he gave her the same spiel, and she's very convinced he's lying through his teeth. We brainstorm and she calls this guy back and let him have it with both barrels. Told him she wasn't clear before about who she was in her position previously, but that she was a caseworker that represented services through the Department of Mental Health and the individual received state supports through Medicaid and was currently under guardianship with PA's office, whom also was herself an attorney. And that we were waiting for a phone call back from the Bar Association about his credentials and record, but that he had until the end of the week to file the paperwork the family had already paid him to complete. She explained that we worked in enough guardianship cases to understand how this worked, and that there was nothing that could possibly be holding it up that long, and an official complaint would be made before we got DMH and DHSS involved to pursue guardianship. The way she told me the story, she could basically hear the guy crapping his pants on the other end of the phone, and he began to apologize profusely and suggested it would be done that day. He admitted to her that he had been busy and continued to drop the ball on the paperwork. TLDR, social worker called attorney out on lying about submitting guardianship paperwork after putting family off for months, and he folded like a napkin. Edit, clumsy thumbs, mobile spelling errors. Got caught in an incident which the public defender met with me and took my terms for. Please immediately. Here goes. As a younger guy I went without car insurance for a while. Couldn't afford it with the job I had. Cue me driving somewhere in town. Weather was wet and rainy. I stop at a red light, wait for my green, and begin to make my left turn. No green arrow. There were no other vehicles at the intersection and none immediately entering it from a short distance. This dude, who doesn't speak a word of English, comes flying through from the other side and clips my back bumper. My only warning was the flash of the headlights from his car a second before impact. I pull over in the middle of the highway, not busy, and insist on calling the cops to make a statement. Car gets parked, cop drives me home. Since no insurance, which I admitted to, I rode a whole 2 blocks in the back of a K9 unit. Get to the defender's office later. Tell him I'm willing to take the no insurance if the failure to yield is dropped. Other guy claims I ran a red light and cut him off. Defender accepts court date just in front of the judge. Defender lays out the terms. Judge accepts and I pay a $300 fine and lose my license for a month. Insurance for the 2 months I didn't carry it would have been around $300 either way. Come to find later, since I had a failure to yield dropped, I was safe from the lawsuit the guy tried filing against me for $9,000 in damages to his car. A broken headlight on a 1999 Nissan Altima, $9,000. As it costs that much, I'm thinking point was completely okay with the sentence too, since I wasn't out any more money than I normally would have been. And I got to hear a very Southern African lady tell the judge, before I went up, "I'm sorry, I was acting a fool," which isn't a thing you'd normally hear in West Central Minnesota. Sorry for format, on mobile. Not an attorney, but worked for drug and mental health court in my last job, and saw some crazy shit. Twice I saw the same guy try to escape from custody and get the beat down by the sheriff's department. He was on PCP so strong as fuck. The second time it was so bad I swore I was about to witness him get shot to death on the floor of the courtroom, because he had every deputy in the building on him and 4 responding deputies and still was resisting, and they couldn't control him. They eventually got him spread eagle and handcuffed him with 2 handcuffs on each limb and held him down until EMS could sedate him. This all while other drug court people and staff watched. I was shaking so hard the commissioner told me to go sit in his chambers another time. A client had told me one story about where they had been and how they missed their appointment and then missed intake for drug treatment at my facility. So I testified nothing is on record in drug court. You just have a conversation at the bench to this effect before they spoke and told the commissioner the new date of their appointment and the new date for intake. Then when it was their turn to speak, they either told the truth or gave a new lie that was completely different than what I said, and said they had no interest in going to drug treatment and said that this beaches cunt coerced me into going to drug treatment. I was like, oh shit, I swear I did not. I just did my job. And they were arrested by the deputy for contempt of court, foul language and lying, brought back the next time I was there, and ended up being kicked out of the program because they just didn't want to do the work. But also miscellaneous stuff like people talking to themselves and being ultra psychotic in mental health court. One lady showed up almost naked at the entrance and the deputy called up to let us know, and the judge was like, I'm not the one expert, what do we do? So her attorney and her worker went down and talked to her, and she was hospitalized for psychosis. People being so high they couldn't even talk right. A couple of young kids that thought they were cute/hard talking back to the judge and ending up in jail for contempt/shock time. One kid thought he was cute/hard, and when his sister was getting taken into custody for dropping dirty at mental health court, he decided to start screaming at her in Spanish and acting like he was going to attack the judge. He got at least 4 deputies on top of him and got to sit in holding. The judge was going to make him spend the weekend in jail, but felt that would play into his so gangster little game that he let him go. And his sister ended up getting extra days because it turned out she planned for that to happen. He ended up apologizing the next week to the judge because his mom had beat the hell out of him so bad for it that DFS was called. Other stuff like the girls/anyone in holding screaming so that they could get attention, or sometimes they were just psychotic, dropping dirty on like every single drug, and people saying snide stuff to the judge and all the staff freezing to see what he would say. My favorite other small one was right after I started. I kicked a woman out of my program at my agency, and apparently her charge was pretty serious. So she didn't just get dismissed with a summons as most of our offenders did. No. She was held in jail until her hearing. She laughed as I asked for her to be dismissed from mental health court, but when the judge said she'd be held until her trial, she got angry and violent and tried to come after me and was screaming, "I know where you work, I know your car, I'll faking kill you, you tiny little bitch." The judge ended up adding a charge for that, since she was specific about where I work, and my client actively tried to kill herself in court. No one is sure to this day how she got the razor past security. She sliced her arm and the deputy held it until EMS arrived. I used to get a bunch of tickets and was always close to losing my driver's license 4 points. Because I was close to losing it, I had to go to court to delay until later So I got points back it to beg for mercy to get the points or fees reduced. I have 2 of these stories, but probably more for later. These 2 are for speeding tickets. Case 1, I'm called up, and the police officer said something like, "I caught this guy speeding using a radar detector, and you know my policy, judge. I do not give any breaks to anyone who uses a radar detector." The judge blasts the cop and basically says that it is his court and he makes the rules. The cop has no say so. I was shocked, and the cop shriveled down. Judge says this guy probably wants to ask for mercy. I confirmed I wanted mercy, and the ticket was dropped from 4 points to 2 and the fine was cut by more than $100. I was ready to laugh and smile, but acted like I was at sad event. Poor cop. Case 2, very small town, and I show up to court and ask for a jury trial, hoping to delay my guilty plea for at least 6 months. They gave me a piece of paper with 25-ish names and told me to pick my jury and that they would see me in 4 days. Oh shit, my strategy has failed me. The day of my trial, the cop asked me why I want a trial. I'm honest and say I need 6 months time to get points back, so I do lose my license. I explain how it works and that I have done it in the past to save my license. Cop leaves to talk to the judge, comes back to ask me to explain it again, and goes back to talk to the judge. Cop comes back and says he is doing something he has never done before and marks my ticket as not guilty. I was shocked and thrilled. If I received even 2 points, I would have lost my license. The cop says, "If I ever catch you speeding again." I thanked him, shook his hand, and drove the speed limit all the way home. I was my own lawyer this time. My ex filed a temporary retraining order, so I had to go fight it. Hiring a lawyer looks bad, but I didn't have the money. Also, my ex got some volunteer prosecutor, so it was me against a trained professional. But I hadn't done anything wrong, so I was convinced I could turn out fine. She accused me of stalking her after we broke up, which was me waiting at her work to try and talk things out when she was done working. She also accused me rapping her. So as I'm hearing her say her side, she also is accusing me of kidnapping her because I locked her out of my house. I know, and that's when it hit me that if I was somehow convicted, I'd probably be sent to jail, as I'm battling for my life against a semi-professional. My oh shit moment was a fortunate oh shit, as the lawyer was completely terrible at her job. She seemed more nervous than I, and she was so much more disorganized than I, probably because my life depended on it, hers not so much. I had screenshots, texts from my ex admitting to abusing me and how she can't control herself. The lawyer then made the point, how do we know it's actually her? Like it's her number, her own confession in text about me. Long story short, I won the case. She and her mother didn't look me in the eye once I won, and quickly left with their tails between their degenerate ass. I should have sued her for defamation of character, as she was going through my town telling every business not to serve me because I was a rapist. I really pity that poor girl. Depending on your type of law, this can be a relatively common occurrence. As an attorney that represents large government agencies that handle some people's most cherished rights, there's a lot of people I must rely on to form a coherent case. I can call you, subpoena you, email your supervisors, force you into a show cause contempt hearing, but I cannot literally force you to do your job correctly and must work around people who fail their end of the bargain. I've had vital witnesses not show to court or call that morning to tell me they can't make it. I've had my own clients not show to court and their supervisors can't be reached to patch up the absence. I've had clients fail to file important paperwork despite my written command to do so. I've seen people lie to me when we are talking and tell a totally different story on the stand. I've heard people be incredibly unprepared despite a detailed checklist I've provided them about what exactly they must be prepared to testify about. Due to the nature of my work and the confidentialities involved, I won't provide specifics. Needless to say, I have a variety of contingency plans ready to roll if my plan A fails. I try to take control over everything I can control. I've learned how to improvise or get creative with hearsay exceptions to make sure the right information is admitted as evidence. And I've seen few oh shit moments from the other side because of how open I'm with discovery. They usually know exactly how screwed they are, and I've seen few real surprises during trial. If you're good and lucky, you can hopefully predict and script what's going to occur. They know what my case will be, because I'll do what I can to shut a case down. If it's meritless, though, I've had a few cases where people have finally admitted their lies unexpectedly, or had someone else throw them, suddenly and aggressively, under the proverbial bus. It's a strange thing to see someone wait until a trial to backstab someone else. Takes some dedication to hide your motives for that long. I clerked for a federal judge in Texas who presided over a number of drug smuggling cases that involved tractor trailers full of narcotics, like 500 pounds of cocaine or crystal meth. The problem with these cases is that the truck driver, who was always in on it, believed that they could feign ignorance and argue that somebody else must have swapped out their legitimate cargo for the illegal drugs. So the way the DA's office prosecuted these kinds of cases was using a theory called bookending. For example, they would put on witnesses who worked at the loading point and they would testify that nobody could have loaded the massive amounts of drugs unnoticed. The DA would then put on witnesses from the scheduled unloading point who would testify that nobody would be able to unload the massive amounts of drugs unnoticed. The resulting inference was that the driver must have allowed his load to be compromised and never intended to drive straight to the unloading point. At one point, we had a case that involved a truck driver who was stopped with 800 pounds of crystal meth. As typical, he argued that he had nothing to do with the drugs and that he was only carrying grapefruits from a produce warehouse. So the DA decided to apply the bookending theory and called, as his second witness, the Uster inspector who worked at the produce warehouse. This gentleman was supposed to come across as an observant government worker whose job was to watch the loading docks. If all went to plan, the jury would conclude from his testimony that nobody could have loaded 800 pounds of meth on his watch. But this didn't go to plan. DA, can you please state your name for the record? Witness, John Smith, DA. And what is your job? Witness, I'm an inspector for the Uster, DA. And for the jury's benefit, what does Uster stand for? Witness, I sat and watched for about 2 minutes as the witness, or Uster inspector, tried to remember what the initials Uster stood for. My attention kept bouncing between the witness, who was visibly sweating and turning red, to the members of the jury, who were just staring at him in disbelief. If memory serves, the case resulted in a hung jury. Back in law school, as a 1L, we would all sit as jurors on the trials of the more senior students in the trial practice class. The trials were presided over by actual judges. The cases were familiar ones, because they got recycled year after year, and were based on real cases, usually from decades earlier, that were considered capable of going either way. The one we had featured a boat accident. Basically, the defendant supposedly sped by the plaintiff's boat, causing a wake that knocked the plaintiff off his boat, whereupon he was hit by a propeller, or drowned or something. Both sides were said to have been drinking, and the defendant was purportedly operating his boat erratically. In the presentation we had, there was a witness to the defendant's boat piloting. In some presentations of the case, I think he would say that he thought the defendant was erratic, but in this one he testified that he didn't see anything wrong with the defendant's boating. This obviously distressed the guy playing the plaintiff's attorney, so he went after the witness for a bit, but totally failed to shift him at all. The plaintiff's attorney decided to wrap up his cross with something like, "Well, Mr. So-and-so, if you think the defendant's boating was acceptable, then maybe we'll see you in the defendant's chair next." Then he sat down with a sheet-eating grin, like he had done some real Perry Mason sheet. It got pin drop quiet, and the judge called the attorneys up for a sidebar. As it happened, the defendant's attorney was a friend of mine. She reported to me that the judge told the other guy something like, "If I ever hear about you doing something like this in the real world, I'll see to it that you never practice law in this state." So, yeah, what not to do in actual court. Think we still gave the plaintiff some money, though. I had just passed the bar exam and landed the job I wanted. I was a prosecuting attorney for the state of Texas. It was my first week, and I was sitting at the prosecution table next to another prosecutor who was conducting a hearing. The defendant in the hearing was charged with DWI. He was also Hispanic and deaf. This apparently necessitated 2 sign language interpreters, and I'm still not sure exactly why. The arresting officer took the witness stand and testified to the details of the offense. The courtroom was packed, though mostly with other defendants who also had their cases set in court that day. The officer testified that at some point after the arrest, the defendant shit himself. In an effort to keep his fesses from going everywhere, he did the 1980s tuck and roll thing with the bottom of his pants. Later, of course, they had to be unrolled and the sheet went everywhere. When the officer said all of this, the audience made all sorts of muffled sounds, laughter, disbelief, you name it. Everyone in the courtroom knew what the officer said happened, except for poor old defendant. Then we all got to watch in painful anticipation while, in total silence, the first interpreter signed words to the second interpreter, who then basically pantomimed the whole thing to the defendant. She squatted, put a strained look on her face, clenched her fists, then used her hands to mimic fesses falling onto the ground. She then pantomimed the poop going down the inside of her pants, catching it with her old cuff before it hit the ground, then its later release onto the floor. She even pantomimed an anonymous onlooker's horror and disgust at what happened. Everyone got to watch the defendant's expression slowly turn from shock to utter humiliation. He eventually closed his eyes and looked down, refusing to watch any more of it. He clearly had no recollection of any of it. It was then that I was 100% sure I had made the correct decision to go into criminal law. I'm a young defense lawyer, run my own practice and get a number of clients that young solos simply do not get. In my passive-aggressive state, I'm probably considered a jerk by most prosecutors, but people hire me because of my record. Truth be told, I don't know why my clients get such unbelievable deals other than the fact that I'm extremely good at bluffing. I've had plenty of unique moments, but one in particular stands out. I was representing a client who is being accused of a crime that resulted in another individual's death. He is facing multiple felonies, decades in prison. We get to the status conference and I have made a deal for him to get one misdemeanor and no jail time on a deferred sentence. In other words, after probation it is dismissed/sealed. No fine. The judge takes one look at the deal, looks at the prosecutor, and asks him if he read it correctly. The prosecutor says yes. The prosecutor attempts to keep talking. The judge cuts him off, looks at me, and says directly to my client, I kid you not, Mr. I have no idea how your attorney continually drives into this county and convinces the prosecution that the most dangerous individuals in this state should not have any penalties. But he does. He is worth every penny of whatever you paid him. But mister, you had to know I would not accept this deal when you entered the courtroom today. This is less than people get for some traffic offenses. The judge then looks at me and says it's difficult to sentence your clients because you charm everybody to death and you get unreasonable deals from them. I can never approve. I'm going to reset this one. Come back with something you know I can approve. Apparently, somebody dying is a big deal. I'm not a lawyer, but a salty child of divorce. I'm 21 and still going to court to support my mom when my sad excuse for a father tries to pull. Well, I'll explain. Got long. There's now a TLDR at the end right square bracket. 2012 my parents file for divorce and my father, being army and sole breadwinner, gets the benefit of the doubt for quite some time. My mom got my siblings and I, while he got every Thursday and first, third, fifth weekends. 2013 we have a month to get out of the house with whatever we can take with us, and we move out to live with my grandparents in BFE. We couldn't get everything by the deadline, so he got to keep what was left, most of my things. 2015 divorce is finally final. After he dragged it along for age. 2018 we are still in court because he refuses to pay child support and various other things he chose not to pay. While he was waiting for us to bleed dry throughout the divorce, he decides to defend himself, and that was the worst and most hilarious decision I've ever seen him make. And he once parked a tank on a cliff and had it tip with all his men in it. They were fine. Me being me, the first thing I see when he opens his briefcase is a buddy buck, and to those that don't know, it's a supermarket dollar kids use to play games while their parents shop for groceries, which just killed me. We were lucky enough to get a female judge, and that just means that he would automatically have zero respect for her. For an hour he attempted to interrupt her, would shout that our lawyer was lying, he stumbled on his own words, and brought up the most random things. His argument to the judge was that since other events in the past had a deadline, that he shouldn't have been to owe anything, now that the deadline has gone and went. The man argued that if he doesn't want to pay something he should be able to wait it out and not pay anything. Eventually she sat him down in the box next to her. Judge: how long were you in? Stupid. 2x years. Judge: I don't see how you lasted so long seeing as you can't follow orders. You must have been a terrible soldier. Stupid. Leans into Mick: I was a great soldier. My mom and I were in tears trying not to laugh. This was the only thing he ever thought he did well, and he just had a woman look down on him and tell him he was wrong all along. TLDR, divorce from 2012 was drawn out for 3 years and now my mom and I are still being brought back to court 6 years later to watch my deadbeat argue that he shouldn't have to pay what he owes because it's been so long since they told him to pay. The female judge was fed up with him and sat him down to tell him you can't follow orders. You must have been a terrible soldier. And my mom and I had to restrain ourselves from shouting damn in court.